Cute little Tanner. Good afternoon, everyone. We're not supposed to start for about 3 more minutes, so I'm going to give the scoring panelists and everyone a chance to get connected here. We'll get started shortly. All right, thank you. Well, good afternoon to everyone. I am Michelle Jones. I am a magistrate and I work in Douglas County Courts. So I'm going to be your presiding judge for the mock trial this afternoon. I'm excited to watch you all present. I also judged the Arapahoe County tournament last week. It's a pretty cool thing and I was really impressed. So I'm excited to see you all perform today. We do have some scoring panelists that are here in the virtual courtroom as well. I'm going to ask each of them to briefly unmute themselves and introduce themselves very briefly for the record. So scoring panelists, could you introduce yourselves?
I'm Sarah Burnett.
Thank you, Ms. Burnett.
Hi, everyone. My name is Nicole Speraza. I'm an attorney in the Denver metro area, and I'm happy to be here. So I'm excited and look forward to hearing you all.
Thanks, Ms. Speraza.
Hi, everyone. My name is Adeline Solentich. I'm a family law attorney in the Denver metro area, and I am happy to be here.
Thank you. We also have a courtroom monitor. Would you like to introduce yourself briefly?
Good afternoon. This is Dawn Rogers. I'm the courtroom monitor for today.
All right, thank you. And so at this time, I understand we have these two teams here ready to go. Which team is the prosecution team? And please just tell me your team code and not your actual school name.
It's Team Breyer.
Team Breyer for the prosecution, thank you. And for the defense?
Team Kavanaugh.
All right, thank you. And each side, I'm going to ask if you are ready to get started. Team Breyer, are you ready?
Yes, Your Honor.
Team Kavanaugh, are you ready?
Yes, Your Honor.
All right, thank you. I'm going to ask each side provide this scoring panelist as well as myself a copy of your trial roster with your team code. So just with Breyer or Kavanaugh, no other identifying information about your high school. And can you put that in the chat feature? Are you able to put a PDF or a list of your team participants in the chat feature?
Your Honor, I think we already sent our team rosters to someone in the mock trial world that should disseminate them down, but I'm not really sure because I don't have those.
Okay, thank you. And for my scoring panelists, do you in fact have the team rosters? I guess I could have asked you that first.
I do not have a team roster.
I do not have one either.
Okay. I know for each mock trial, each county's kind of doing their own mock trial. The one I did last week, the teams just put a PDF of their trial roster in the chat feature. I understand maybe you have already sent it somewhere, but I don't know that we have that.
I can go search through my email and find it and download it.
Okay. And for Team Kavanaugh, is there a way for you to get a trial roster as well? That might help our scoring panelists just to have the names of the witnesses.
Yes, I believe so.
Okay. If you are able to do that, why don't I give each team a few minutes, and also we'll go around and have everyone introduce themselves and who they're going to be playing so that the scoring panelists can also write that down. That might be enough. If you can't find a PDF or put it into the chat feature, that's fine. We'll just make sure the scoring panelists get it, make sure they know who's who before we get started so they can score appropriately. All right, thank you. Is there anyone video recording? Looks like no. All right. If there are video recorders present, both teams do have to approve to the taping of the round. So it appears that the parties on each side, prosecution and defense, are not taping. I also should inform both teams that the Colorado Bar Association might be taking pictures of this virtual courtroom. They also might be taking some video from these rounds. And by participating in this tournament, you have granted your automatic permission to the use of any photos by the Colorado Bar Association, so that might happen.
Judge Jones, this is Dawn Rogers, the court monitor. May I please interrupt to ask the person who is using the username ckdrago@yahoo.com to identify themselves?
Thank you. You may. CKDRAGO, can you please identify yourself or how you're connected to this proceeding?
And I am asking if they can send a response through the direct message that I sent to them.
Close it? How do I just close it off?
I'm sorry, who is this?
How do you know I'm in it? Everyone can see me?
We can hear you. We're just wondering how you're connected to this.
I'm leaving the meeting now, sorry.
Okay. All right, and there we go. It looks like that party has left. Thank you, Ms. Rogers. All right, if there's anyone in the gallery connected with the teams, with teams that are not competing in this round, you do have to leave the courtroom. So thank you, Ms. Rogers, for identifying that party. If anyone is connected with another team not competing in this round, they do need to leave this proceeding. I'm going to remind both teams that I will not be allowing any recesses here today unless there's some sort of a health emergency. If so, let me know right away. Otherwise, you will not get a recess once we get started. For my scoring panelists, I'll ask each of you if you have any reason to be biased in judging either of the teams here today, or if you have any concern based upon the parties you can see on the video that you have any reason to not be able to fairly judge this round. Ms. Burnett, any conflicts that you can tell?
No, Your Honor.
Okay, and Ms. Sparaza, any conflicts that you can tell?
No, Your Honor.
All right, and Ms. Zelentich, any conflicts that you can see?
No, Your Honor.
All right, thank you. And I'll ask also for each team, for any of the team members, if you have any reason to believe you have any conflicts either with myself or any of the scoring panelists, please just raise your hand on your video screen. And it looks like no conflicts have been identified. All right, thank you. I will remind both teams as well as the coaches that any disputes that arise out of this competition have to be reported in accordance with the competition rules. You do have to be compliant with time requirements, and your time compliance will be considered in scoring your individual performances. So make sure you're aware of the time. I know we have timekeepers here that will also be giving us cues and notes. All right. It also appears there are no coaches or team members inappropriately in this virtual courtroom at this time. So with that, then I will ask each side to go ahead and introduce your participating team members. And if you would do so slowly, it looks like we have one of the rosters up for Team Kavanaugh in the chat feature. So I appreciate that, that helps. But when you introduce
Judge
yourself.
Jones, this is Dawn Rogers. Can we just make sure that we don't get started until we know that there's no conflicts in the other virtual courtrooms? And then can I also ask both teams to confirm that all participants who are going to be participating in this round are present in the virtual courtroom, as I do have a couple of people on the rosters from each team who I do not have logged in, and I just want to confirm that everyone is been able to access and participate that should be.
Sure, thank you. And so first, for Team Breyer, the prosecution, are all your team members that are participating today connected?
Yes, Your Honor, it looks like it.
Okay, so you're not waiting on anyone. No one's told you they can't connect or there's any concern about that for Team Breyer. Okay.
No problems yet, thankfully.
All right, great, thank you. And for Team Kavanaugh, same question. Are all your team members that are participating connected that you can see?
Yes, Your Honor.
Okay, and you don't have anyone with connection problems or that you're waiting for?
I don't believe so.
Okay, thank you. And then what I will do is I will, again, let both teams introduce their participating team members, if you would go slowly. And then the last thing I'll do is I'll swear everyone in. And then before we actually start with opening statements, Ms. Rogers, I'll just make sure there's no conflicts in other courtrooms. Okay, all right. So if I could have the prosecution, please introduce your participating team members.
Yes, Your Honor. Good afternoon. My name is Amanda Brockler, and along with my co-counsel, we represent the people in this case today. Today, I will be performing the direct examination of Detective Markowitz, as well as the cross-examination of Professor Van Owen and the closing for the prosecution case.
Thank you.
Good afternoon, Your Honor. My name is Grant Rose, and I'll be performing the direct examination of Alex Fuentes and the cross-examination of Taylor Perkins in this case.
And I'm sorry, what was your last name, sir?
DeRose.
How do you spell that?
D-E-R-O-S-E.
Thank you. Next
Good
member,
afternoon, Your Honor. My name is Jacob Aragon. Today I'll be giving the opening statement, as well as the direct examination of investigator Kyle Kuzak and the cross-examination of Avery Becker.
Thank you.
Your Honor, at this time, permission for the witnesses to introduce themselves.
They may.
Good afternoon, Your Honor, the jury, and the opposing side. My name is Alicia Probasi, and I am Jordan Markowitz.
Thank you.
Your Honor, my name is Amia Sharma, and I am Alex Fuentes.
Good
Thank
afternoon,
you.
Your Honor. My name is Sarah Smith, and I am Kyle Kuzak.
All right. Thank you. And for my scoring panelists from the prosecution team, did you catch all of those names and who they're portraying?
Yes, Your Honor.
Okay.
Yes, Your Honor.
Okay, no one needs it repeated then. Okay, thank you. All right, then for the defense, I will ask you to introduce your participating team members.
Good morning.
Actually, I do have a question, Your Honor. With the witnesses, it looks like they are on the scoring sheet, but according to the names that are on the chat, it's, I believe, I'm not sure whether it's the witness names that are identified on their Zoom, or
Your
if it,
Honor. Sorry, we identified our witnesses on our Zoom names with the character name that they're playing today, and I also just put our trial roster in the chat. It just uploaded.
Okay.
So hopefully that helps with the confusion. Thank you.
All right. Thank you very
I
much.
think that's all I need. Thank you.
Okay, great. We just want to make sure we get the right names on the score sheets here. Okay, for the defense, could you please introduce your participating team members?
Good morning, Your Honor. My name is Lana Pentino for the defense. I will be direct examining Avery Becker, cross-examining Detective Jordan Markowitz, and delivering the closing argument. Permission for my co-counsel to introduce themselves.
They may.
Good afternoon, Your Honor. My name is Sydney Dragovich. I will be direct examining Professor Blake Van Owen and cross-examining Kyle Kuzak.
Thank you.
Good afternoon, Your Honor. My name is Evelyn Proctor. I will be conducting the direct examination of Taylor Perkins and cross-examining Alex Cifuentes, as well as delivering the opening statement.
Thank you.
And permission for our witnesses to introduce themselves.
They may.
Good afternoon, Your Honor. My name is Katie Greenfield, and I am Professor Blake Van Owen.
Thank you.
Good afternoon, Your Honor. My name is Chloe Scott, and I am Taylor Perkins.
Good afternoon, Your Honor. My name is Ellie Bronson, and I am Avery Becker.
All right, thank you. Well, at this time, oh, and I should make sure my scoring panelists, did you get all of those names? If anyone needs anything repeated, just unmute yourself and let me know. All right. It looks like the scoring panelists are all set then. And I do see both teams were able to put their roster in the chat feature, so I really appreciate that. Thank you. At this time then I am going to swear everyone in, and then I will ask the courtroom monitor, Ms. Rogers, whether we can get started with opening statements. So I will swear everyone in at this time. So for team members, will you all please raise your right hands? Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? If
Yes.
so, say I do.
I do.
Thank you. And witnesses, same thing. I'm going to ask you to please raise your right hands. Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? If so, say I do, please.
I do.
I do.
All right, thank you. And for any gallery members, I understand some of this is maybe live streamed, including for teacher and coach attorneys, family members and friends. I'm also going to ask you all to raise your right hands, although I know I can't see you right now. Gallery members, including teachers and attorney coaches, family members and friends, do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? I'll give them all a minute to answer wherever they are located if they are streaming this. All right. And finally, for my scoring panelists, I'm also going to ask you to please raise your right hands. Scoring panelists, do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do.
I do.
All right, thank you. And at this time, those are all of the pretrial procedures that we're required to go through. Ms. Rogers, do we have the all clear to get started, or are we waiting on conflict checks from other courtrooms?
Your Honor, we have the all clear to get started. I will note that I can see the trial roster for Team Breyer. I do not see a roster for Team Kavanaugh. So if that can please be shared with everyone.
Okay, it looks like it's in the chat feature at 1:08 p.m. I see it was sent to everyone. If you scroll up in the chat, do you see it now?
I do, thank you.
Okay, all right, so we do have that. Great.
Your Honor, before we get started with openings, could we go over preliminary trial matters?
You may.
We just have two. The prosecution asks that the jury be read the jury instructions constructively before closing.
Okay, any response from the defense on that request?
That's fine, Your Honor.
All right, that will be granted.
and that for the prosecution closing, we can reserve time at the end for a rebuttal.
All right, and that is within my discretion. I will grant that request as well. If any time is remaining, you may use that on rebuttal.
Thank you, Your Honor. That's all from us.
All right, so no other preliminary matters for the prosecution. Are there any preliminary matters from the defense?
No, Your Honor.
All right, thank you. Well, with that then, we can get started with the case, and I will begin by allowing the prosecution to go first with an opening statement.
Thank you, Your Honor. Before I begin with the scoring panelists and the judge, can you see me okay and my audio is okay?
Yes, I can see you fine. We can hear you.
Perfect.
Thank you.
I would get back at him if it was the last thing I did. That's what the defendant promised her mother she would do to the victim, Mackenzie Brackman. You see, Mackenzie Brackman was a beloved high school mock trial coach. He was a local attorney, but spent most of his time teaching high school students the rule of law. While most of his students adored him and appreciated his time, there was one student in particular that gave Coach Brackman a hard time. The defendant, Avery Becker. Because the defendant rarely did the work they were supposed to do, they argued with Coach Brackman. They were rash, they were emotional, and frankly, unstable. At practice one day, Coach Brackman attempted to give the defendant constructive feedback, but of course, the defendant wasn't having it. They stormed out of practice, angry and unhinged. They went to Coach Brackman's car and vandalized it by writing with permanent marker all over it. Of course, when Coach Brackman saw his car, he immediately kicked the defendant off the team, causing the defendant to be even angrier. That's when the defendant told her mother she would get back at Coach Brackman. It was the last thing she did. So that night she planned to get back at Coach Brackman. The next day she skipped school and she made a plan to break into Coach Brackman's home and vandalize his home. However, there was one problem. When the defendant arrived to the house, the victim was home. A struggle ensued and the defendant ended up killing the victim rather than getting caught. Because like the defendant said, she would get back at Coach Brackman. It was the last thing she did. Today, you're going to hear from 3 prosecution witnesses. First, you're going to hear from investigator Markowitz, who will tell you exactly how she's able to pin Avery Becker at the scene of the crime. Next, you're going to hear from investigator Kuzak, who is in charge of reconstructing the crime scene. In addition, I anticipate that investigator Kuzak will tell you that this was a burglary gone bad. And finally, you'll hear from Alex Cifuentes, who was a friend of the defendant. But she will tell you the plans that Avery Becker shared to her about breaking in to Coach Brackman's home. Throughout their testimony, I want you to keep in mind 3 things. 1, who had the motive to kill Coach Brackman? 2, who had the means to carry out this murder? And 3, who had the opportunity to commit this crime? And by the end of this trial, we'll have proven to you that Avery Becker is the only person to match those 3 things. Now, as a prosecution in this case, we carry that burden. And the burden is to prove to you each and every element beyond a reasonable doubt. And we welcome that burden. We will prove to you each and every element of the crimes charged. How in second-degree burglary, Avery Becker knowingly, feloniously, and unlawfully broke into the residence of Coach Brackman. And how in first-degree murder, Avery Becker ended up killing Coach Brackman in the process of burglary. Keep in mind, members of the jury, that Avery Becker does not have to show any intent in order to be charged with first-degree murder. At the end of this trial, my co-counsel will come before you and will ask that you find the defendant guilty of second-degree burglary and murder in the first degree. Because the defendant was rash, the defendant was emotional, the defendant was violent. And because the defendant would get back at Coach Brackman if it was the last thing she did. Thank you.
Thank you, Mr. Aragon. Is there an opening on behalf of the defense?
Yes, Your Honor.
You may go ahead when you're ready, counsel.
Thank you. Just before I start, can everyone hear and see me all right?
We can, yes, thank you.
Your Honor, members of the jury, may it please the court. My name is Elbert Proctor, and my co-counsel and I represent Avery Becker, the defendant in this case. Ladies and gentlemen, carelessly performing a job will never give you the proper results. When someone takes the easy way out of a problem, important things get overlooked. Mistakes are made, and the unavoidable result is an unreliable outcome. I have just described to you the exact characteristics of the Denver Police Department in their investigation in this case. Mackenzie Brackman, a victim of murder, was an attorney who continually fought for justice. He will never receive justice due to the police's many failures and omissions to their investigation. First, the investigating officers made up their minds before they even began, taking the easy way out and ignoring important evidence. Second, the police also failed to consider relationships and motives that exonerate Avery Becker. And third, the police investigation was messy, haphazard, and replete with unreliable shortcuts and omissions. The evidence of carelessness and neglect by the Denver Police Department will raise serious and reasonable doubts that can only result in finding Ms. Becker not guilty. Today, you will hear how the Denver Police Department not only overlooked obvious suspects, but allowed unreliable and insufficient evidence to be used against my client. They took the easy way out, blindly trusting a jealous rival rather than earnestly searching for the truth. On March 6, 2020, Mackenzie Brackman was tragically murdered in his own home. Despite evidence proving my client's innocence, the state would have you believe that Ms. Becker, a young high school student, committed this crime. That is absurd. The police refused to keep an open mind during this investigation. They found an easy suspect, a teenage girl who had a difficult relationship with her teacher, and they locked themselves in. They had their target and refused to consider any alternative, no matter how promising the lead or strong the evidence. You will hear time and again throughout this case how wrong the police were in their assumptions. First, you will hear how the investigating officers took the easy way out and ignored important evidence exonerating Ms. Becker. You will hear how they already had their minds made up before even beginning to collect evidence. Members of the jury, you will learn how the Denver Police Department failed to request cell tower data from other known suspects. Not only this, but you will hear evidence that the police completely disregarded Ms. Becker's alibi when they failed to simply check the location of her friend Taylor Perkins' phone, the fellow student Ms. Becker was with on the day of Mr. Brackman's murder. All because the officers made up their minds before the investigation began and ignored the mounting evidence that pointed to other suspects. Second, the police failed to consider relationships and motives that exonerate Avery Becker. In particular, you will hear how the Denver Police Department failed to investigate the relationship between Ms. Becker and fellow student Alex Fuentes. The evidence will show that Ms. Fuentes had always been jealous of my client. The reliable testimony will be clear. These two were not friends. You will hear about how they were constantly competing for the top spot on their mock trial team, butting heads at every turn. You will learn about a childish rivalry that was seemingly harmless until Alex Fuentes took it too far. You will hear how the police chose only to question witnesses that confirmed their own assumptions. Contradicting stories will not be tolerated by them. They even failed to question other students on the mock trial team. You will also hear about a former client of Mr. Brackman's, Mr. Rollins, who went to prison after losing his case. His daughter, Blair Rollins, is a classmate of Miss Becker's, and the evidence will show that Miss Rollins has both motive and animosity for the victim. Moreover, the evidence will show that since the day of Mr. Brackman's death, Blair Rollins has been nowhere to be seen. Finally, ladies and gentlemen, you will hear how the police investigation was messy. So sorry, I just turned off my camera. Messy, haphazard, and reckless, replete with unreliable shortcuts and omissions. Expert witness Professor Blake Van Owen will explain about the police department's failure to use Celebrite, a forensic phone searching software. You will hear how Detective Jordan Markowitz, despite extensive training, took shortcuts in his investigation, how he ignored the obvious fact that actual physical evidence is more reliable and authentic than mere screenshots of that evidence. The screenshots break the chain of custody and leave the door wide open to tampering and other injustices, and this is in a murder case. Moreover, the evidence will show that the inappropriate screenshots were in fact provided by Alex Fuentes, a teenage student who you will hear constantly had it out for my client. Detective Markowitz's negligence in relying on these suspect screenshots will raise significant reasonable doubts. The murder of Mackenzie Brackman demands justice, but from the very beginning of the police's investigation, only injustices have occurred. 1, the investigating officers made up their minds before they even began. 2, the police failed to consider relationships and motives that exonerate Avery Becker. And 3, their investigation was filled with shortcuts and omissions. It is the state who must prove beyond a reasonable doubt that my client committed this crime. They will fail at this task. The evidence will clearly show that other suspects, stronger motives, and reliable evidence should have been the focus of the police, but they were not. The justice Mr. Brackman deserves is the same justice that should exonerate Ms. Becker. After hearing all
right, and your time is up. I apologize.
It is all right.
I do have to stop you at that point. Thank you. Ms. Barraza, I think you're no longer on mute. If you could mute yourself. And then it also appears that the courtroom monitor may no longer be with us. Ms. Rogers, are you still in the courtroom? Okay.
I think I am on mute. I'm just on a separate phone. So let me see if I can do that on the other device as well.
Thank you, Ms. Barraza. There was like a slight amount of background noise during the opening statement. So there you go. It looks like you're good now. Okay, so Ms. Rogers, our courtroom monitor, I'm not sure what happened or why she dropped off. Typically when that happens, it'll let someone else know they've become the host of the meeting. And so, you know, with this being a new format, it's very different. But did any of the students, any of the participants get any kind of notification that they are now the host of this meeting when she dropped off?
It didn't, I don't remember exactly who it said was the host, but it did say that the host status has changed.
Yeah, and I saw something pop up, but I didn't catch the name.
I believe it was Amanda Brockler is the new host of the meeting.
Okay.
I think that means we win by default, right? I'm kidding. How do I change that to someone who's more important than me?
And so I don't, I just got a chat message from one of the organizers of this competition, and they said that Ms. Rogers is trying to get back into the room. So Ms. Pryor, you might have to see if there's, and I don't really know how to better tell you, you might know Zoom better than I do, but there might be somewhere where you have to let her back in. And this obviously doesn't count.
Side, but I don't see anyone waiting in the waiting room. Like I didn't get a notification for that. So
okay. I'll let them know we don't see her trying to get in, but let's just pause and see if we can get her reconnected before we get into prosecution's case in chief. So this obviously doesn't count towards anyone's time or anyone's points. Just another technicality with all the virtual stuff we're living with these days.
Your Honor, does it help if I make you the host? Because I know how to do that.
Sure.
Okay. Just like magic, you're the host now.
Thank you. And I'll see if I see anything pop in. Okay, and the okay, it looks like she's trying to connect now. All right, and it looks like Ms. Rogers, you're back with us. Is that right? I see it appeared now. We went up from 18 participants to 19, and I see the Douglas Elbert connection. I believe that's Ms. Rogers. Ms. Rogers, can you hear us? All right. And I am just communicating again to one of the organizers to see if we should keep waiting or if we're good to resume. So give me just a few moments till I get an answer.
Judge Joan, this is Dawn Rogers. I'm back up and running.
Okay, great. Thank you. All right. Then we have, and Ms. Rogers, we noticed that you dropped off during opening statements. We completed the opening statements, and so now we will continue. And it is the prosecution's case in chief. For the prosecution, how would you like to proceed?
The prosecution calls Detective Markowitz to the stand.
All right. Detective Markowitz, I will simply remind you of the oath that you took at the outset of this proceeding. And so you are under oath. And counsel, you may begin with your witness.
Good afternoon, Detective.
Good afternoon.
Please introduce yourself to the jury by telling us your name and spell your last name for the court reporter.
My name is Jordan Markowitz, Markowitz.
Before we talk about your investigation and your findings, let's get to know you a little bit better. This may be a super obvious question, Detective, but what do you do for a living?
I'm a police officer with DPD.
How long have you been with DPD?
13 years.
What is your current assignment?
I'm a detective with the homicide unit.
Tell us what your duties are as a detective.
Once a crime has occurred and I get assigned that case, I will respond to the crime scene, oversee the collection of evidence, interview any witnesses, and then turn over all of my findings to a crime scene reconstruction expert.
Did you do that in this case?
Yes, I did.
Let's talk about your investigation. Tell us how it started.
On March 6th, 2020, a passing motorist called 911 to report seeing a possibly passed out person on the front porch of a residence.
What was the address of that home?
444 South Flower Street in the city and county of Denver, Colorado.
Who responded to that 911 call?
Paramedics initially responded, but determined the person was deceased, and that's when officers were called on scene.
Once police were called, what happened?
Police arrived, secured the scene, and then called me to come and investigate. I arrived shortly thereafter.
What time did you arrive at the residence on South Flower Street?
2:20 p.m.
Describe what you first saw when you got to the house.
I saw a deceased adult male lying in a pool of blood.
Did you document the scene?
Yes, I took photographs.
Detective, are you familiar with what's been marked as Exhibits 2 and 5?
Yes, I am.
What are Exhibits 2 and 5?
Exhibit 2 is a photo of the victim inside the home, and Exhibit 5 is a photo of a knife we found on scene.
How do you know?
I was there and I personally recorded these scenes.
Are Exhibits 2 and 5 fair and accurate representations of the victim's body and the knife as you last saw them?
Yes, they are.
Move to admit Exhibits 2 and 5 into evidence.
All right, any objection, Ms. Fensano?
No objection, Your Honor.
All right, 2 and 5 will come in.
Permission to publish to the jury by having my co-counsel share their screen.
Permission granted.
Detective, I'm now showing you Exhibit 2. Describe what's happening in this photo.
This is a photo of the victim inside the home. As you can see, the victim's shirt appears to be blood-soaked, and there appears to be a puncture wound on the victim's back.
Did you find anything at the scene that you believe could have caused this injury?
Possibly. We found a large steel chef's knife covered in blood near the body.
I'm now showing you what's already been admitted as Exhibit 5. Is this the knife you found?
Yes, it is.
All right. Thank you, Mr. Aragon. Detective, in addition to there being the victim's body in the doorway, was there anything about the outside of the house that drew your attention?
Yes, I noticed the home was equipped with a Ring doorbell as well as several cameras.
Now that we know what you observed on the outside of the home, let's talk about your observations on the inside of the home. First, did you document your investigation on the inside of the home?
Yes, I had my crime scene investigators take photographs of the inside of the home. However, I later learned that some of the files were corrupted and we weren't able to recover a few photographs.
Well, let's talk about the photos we do have. Are you familiar with what's been marked as Exhibits 7, 8, 9, and 18?
Yes, I am.
Tell us what each exhibit is.
Exhibit 7 is a photo of a kitchen drawer. Exhibit 8 is a photo of a knife block found in the kitchen. Exhibit 9 is a photo of the dining area. And Exhibit 18 is a photo of just inside the back sliding glass door.
How do you know?
I've personally observed these scenes.
Are these exhibits fair and accurate representations of those items when you found them?
Yes, they are.
Move to admit exhibits 7, 8, 9, and 18.
Any objection, Ms. Pensano?
No objection, Your Honor.
All right, thank you. Then 7, 8, 9, and 18 will come in at this time.
Detective, which room did you investigate first?
The kitchen.
What did you find in the kitchen?
I found a partially open kitchen drawer, which I documented in Exhibit 7.
Permission to publish exhibits 7, 8, 9, and 18 to the jury by having my co-counsel share their screen.
Permission granted.
I'm now showing you exhibit 7, Detective.
Right, this is a picture of the kitchen drawer I found. As you can see, it contains several knives.
Okay, now exhibit 8.
Yes, this is a picture of the knife block from the kitchen, and as you can see, there's an empty slot indicating that there's a missing knife.
And now exhibit 9.
Here is the dining area. As you can see, there's a broken plate on the floor as well as a knocked over chair.
Aside from those things, was there anything else that stood out to you around the house?
Yes, I found scuff marks just inside the back sliding glass door, which I documented in Exhibit 18.
I'm now going to show you 18. All right, thank you, Mr. Aragon. Okay, I want to turn back now to the victim. Were you able to determine who he was?
Yes, it was a man by the name of Mackenzie Brackman.
Did the identification of the victim help you further your investigation at all?
Objection, Your Honor. Speculation. This witness has not been entered in as an expert.
Any response?
Your Honor, this isn't speculation. This is Detective Markowitz's rationally based perception of her going through this crime scene and the steps of her investigation. She does not have to be an expert witness in order to testify to her experience.
All right, I'm going to overrule the objection and allow the detective to answer.
I'm going to re-ask that last question. Were you able to determine who the victim was?
Yes, it was a man by the name of Mackenzie Brackman.
And did the identification of the victim help you further your investigation at all?
Yes, once we knew the victim's name, we were able to use their logins to access their Ring account and view videos captured on March 6th.
Are you familiar with what's been marked as exhibits 10 and 12?
Yes, I am.
What are exhibits 10 and 12?
They're videos from the Ring doorbell.
How do you know?
I recovered these videos myself.
Are exhibits 10 and 12 in the same or similar condition as when you recovered them?
Yes, they are.
Move to admit exhibits 10 and 12.
All right, any objection, Ms. Pensano?
Yes, Your Honor, this witness has been not entered in as an expert witness under Rule Code 702 and thus cannot speak to this evidence.
Any response?
Your Honor, this witness does not have to be an expert in order to speak to this evidence. This witness did collect this evidence and can present it then.
All right, I'm going to allow it over objection.
All right, permission to publish to the jury by having my co-counsel share their screen.
You may.
I'm now playing exhibit 10. Walk us through this video, Detective.
Absolutely. So first, we see the intruder kind of looking around and then approaching the front door. And they're trying the front doorknob unsuccessfully. And they will go around to the side gate. And then in the next video,
exhibit 12.
We notice that the intruder approaches the back door and enters the home illegally.
All right, thank you, Mr. Aragon. In addition to the Ring cameras, was there anything else that you learned about the victim?
Yes, we found a number of text and email messages related to something called mock trial.
Why was that useful to your case?
With a little digging, we were able to find out that the victim was a coach for Colorado High School's mock trial team. With this information, we reached out to the school and got the contact information for all the students on the team.
What did you do with that contact information?
We reached out to several students.
Who was the first student that you reached out to?
Alex Cifuentes.
Now, without going into everything that Ms. Cifuentes told you in your interview, because of course that'd be hearsay, Detective, tell us what you did next based on your investigation after your interview with Ms. Cifuentes.
I got a court order to obtain the phone account records for Avery Becker.
Why?
Because Alex Fuentes had told me that Avery Becker texted Alex with a plan to trash the victim's home.
Objection. Hearsay.
Any response?
Yes, Your Honor. I think that the defense is objecting to this being hearsay within hearsay. I'd like to first address the hearsay from the defendant. This is a statement made by the defendant, and her collecting this evidence from Ms. Cifuentes is not hearsay because it's not offered for the truth of the matter, but as the effect on the listener. This laid the foundation for her moving on through her investigation.
All right, any further reply?
Yes, Your Honor. Even if it is not being offered with the truth of the matter asserted, she is still speaking to knowledge that Alex Cifuentes spoke, not the actual witness that is testifying today. Thus, it would still be considered hearsay.
All right. I am going to sustain. Ms. Brockler, you may continue.
Okay. Why were these text messages relevant?
Simply because Avery Becker had texted Alex Cifuentes with a plan to trash the victim's home.
Detective, who is Avery Becker?
Avery Becker was a high schooler on the victim's mock trial team.
Through the course of your investigation, did you ever view a photograph of Avery Becker?
Yes, I did.
At this time, Judge, I ask that everyone in the virtual courtroom turn on their cameras so that this witness can make an identification of the defendant.
All right, if the parties in the virtual courtroom will turn on their cameras.
Detective, do you see the defendant in this courtroom?
Yes, I do.
Please identify Avery Becker by telling us what they look like and an article of clothing they're wearing.
Ms. Becker is wearing a dark gray blazer, and she also has a black shirt underneath, and she has brown hair.
May the record reflect that the witness has identified the defendant subject to cross.
It will so reflect, thank you. And everyone can turn your cameras back off now if you're not counsel in this round.
How were Avery Becker's cell phone records important to your investigation?
They corroborated what Alex Fuentes told me about Avery's plan, and they also informed me of Avery Becker's location at the time of the murder.
Before we talk about what you uncovered with Avery Becker's records, let's first understand your area of expertise when it comes to cell phone records. Do you have experience working with cell phone records in a criminal investigation?
Yes, I do.
What type of training do you have in the field of cell phone data and analysis?
In addition to regular training we receive at the Police Academy, I have specialized training in cell phone technology, data, and analysis.
Tell us about that specialized training.
I have a cell phone technology and forensics recovery certification from the American Academy of Law Enforcement.
And what did you have to do in order to get certified?
I had to pass a 3-day training course and complete a certification test.
What did that training course entail?
We learned about the types of cell phone data, the records that can be obtained, how to use software such as the Celebrite system, and how to acquire and interpret both cellular records and cell tower data.
And the training that you received during that course, do you use that training as a homicide detective?
Yes, I use it constantly as a homicide detective, and I've downloaded the contents of literally hundreds of phones.
Do you also use and analyze cell tower data on a regular basis?
Yes, I do, and I have in over 50 cases.
Did you do that in this case as well?
Yes, I did.
Did you come to any conclusions based on the data you received?
Absolutely.
And the methods you used in coming to your conclusions, are those regularly accepted and relied upon in the scientific community?
Yes, they are.
At this time, we move to tender Detective Markowitz as an expert in the field of historic cell site analysis and interpretation.
Any objection to that endorsement?
No objection, Your Honor.
All right, the detective will be so endorsed.
Detective, let's talk about what records you obtained in this case and what you learned from them. First, what are CDRs?
CDRs are a record of every call that a cell phone has placed. They can also inform someone of the location of the cell phone.
How does it show you the location?
In general, a cell phone will connect to the nearest tower. With this connection, we can determine the location of the cell phone at that time.
What did you learn from Avery Becker's cell phone records?
We were informed of Avery Becker's cell phone location at the time of the murder.
What was that location?
Avery Becker's phone was at the scene of the crime at the time of the murder.
Thank you. No further questions.
All right, thank you. I will turn it over now for cross-examination. Ms. Fensino?
Thank you, Your Honor. Detective Markowitz, Mackenzie Brackman did criminal defense work for a living, correct?
Correct.
As a criminal defense attorney, he might have disgruntled ex-clients.
Possibly.
Nowhere in your statement did you mention ever interviewing any of these ex-clients.
Correct, because we found such a large lead and almost a confession, really. And so looking into another lead might distract from the main course of the investigation.
Nor did you mention requesting cell tower records from any of his ex-clients.
No, because once again, the only lead in this case is Avery Becker.
Instead, you focused your investigation on high school students?
Yes.
You conducted an interview with mock trial high school student Alex Cifuentes.
Correct.
And as a result of this interview, you discovered text messages between Becker and Cifuentes.
Correct.
You obtained these text messages sent through screenshots?
Correct.
So Cifuentes' phone and its contents, including the text messages, were never processed or properly searched by the police.
No, however, there was no reason to doubt what Alex Cifuentes had sent me simply because Alex Cifuentes in their interview kind of told me the exact same thing that the screenshots had. So there's no reason to doubt what Alex Cifuentes had sent me.
But since the evidence was not obtained directly by law enforcement, the evidence could have been tampered with.
It's very, very unlikely. And we can say with a degree of certainty that it wasn't.
But you would have to agree that there is a chance.
A very minuscule chance, yes.
Is it true that photos of blood drops were taken at the crime scene?
Blood spatter, yes.
However, the photos somehow became corrupted and could not be recovered?
Correct.
Is it true that cell phones usually connect to the nearest cell tower?
Correct.
However, this isn't always true.
Sometimes, yes, it's not true.
If a lot of people are using their cell phones in one particular area, a cell phone may connect with the tower further away.
It is possible in very rare scenarios.
So there is no guarantee that the CDR data accurately reflects where Becker's cell phone was on March 6th, 2020.
I disagree, because in my expert opinion, we can say with a degree of certainty that Avery Becker's cell phone was connecting to the same tower. We can also say that since we were able to recover the cell phone account records and every single time that we did at various times during March 6th, since it was coming from the same tower, we can say with a degree of certainty that it did come from the same tower.
However,
and the one that's closest.
However, you must agree that there still is a small chance that that could have occurred.
Objection, Your Honor. This has been asked and answered.
All right, I will sustain if you'll move on.
Okay, thank you, Your Honor. Detective, do you remember giving a sworn-in statement before this trial?
Yes, I do.
Do you remember signing your name on that statement?
Correct.
Detective, if you will give me one moment, I will let you know what page to turn to read your statement.
Objection, Your Honor. If the defense is impeaching this as improper impeachment, they haven't locked Detective Markowitz into any testimony that she might have misstated.
All right, Ms. Pensino, do you have any response?
Yes, Your Honor. If you'll give me a moment, I can clarify what testimony she has misspoken on.
Okay. I'll give you some leeway if you would like to.
Thank you, Your Honor.
Your Honor, can I ask that the defense re-ask my client or my detective what the testimony was to confirm what she said?
Okay, and so the testimony that was just given was that there was an objection that had been asked and answered, and she did previously confirm that, yes, it was possible.
Yes, Your Honor, if I could clarify really quickly, the witness said that it was not possible for Avery's phone to have connected to a tower further away, but in her testimony, it says that, yes, that could have been a possibility. And if you give me a moment, I'm trying to find the exact page so she can read it out loud for everyone.
Okay, I believe, and for the witness, I'll ask the detective, what is your testimony with regard to whether it's possible or not? Because I believe you said it was possible.
Yes, Your Honor. I said with a degree of certainty, and the definition of that term is that, a degree of certainty means, there's a pretty big chance that it wouldn't happen, but it also implies that there is a chance that it would. So I did, by saying a degree of certainty, I did imply that, yes, it is possible. And so I believe that this impeachment is improper.
Okay, well, I'm not, thank you. I don't want the witness's legal opinion, but Ms. Pensino, I'll ask you to continue with your cross.
Thank you, Your Honor. Give me one moment. Detective, I'll ask another question. In your testimony, do you recall stating that that cell phones can connect to cell towers further away?
Yes, I did say that.
And could that be a chance for Avery Becker's cell phone to have connected to a cell phone farther away?
Objection, Your Honor. This line of questioning has already been asked and answered.
Okay, I'm going to allow the witness to answer just to clarify.
Can you restate your question?
Yes, of course. I was saying that because of what you had just previously stated about CDR data and cell phones, you would have to agree that there is a chance for Avery Becker's cell phone to have connected farther away.
Yes, there is a very minuscule chance.
Thank you, Your Honor. No further questions.
All right, thank you. Any redirect, Ms. Brockler?
Sure, Your Honor, just 2 questions. Detective Markowitz, why did you start with Avery Becker as your lead?
Simply because there was so much evidence against her. I mean, we have to think about her build, which is very apparent in the Ring cameras as exactly looking like Avery Becker. We also have to consider the text messages as well as the surrounding background that we have on Avery Becker of, vandalizing her coach's car, and also just a lot of the circumstances that happened around that, which I'm sure future witnesses will talk about.
Your Honor, improper use of crimes.
I'm sorry, your computer broke up for a minute there. What was the objection?
I apologize. Improper use of crimes under Rule Code 404B.
Any response?
Your Honor, Detective Markowitz is just showing that in her investigation, she used the fact that Miss Becker had already vandalized Mr. Brackman's car as a indicator that she has a motive against Mr. Brackman to seek vengeance against him.
Permission to respond, Your Honor?
You may.
Thank you. This rule code specifically states that an example of one action or crime cannot be used to talk about the other witness's overall character. Thus, this testimony is not allowed.
Any further response?
Your Honor, I would simply say that this is just what Detective Markowitz relied upon in coming to her conclusion. That it is not the full conclusion, nor are we prosecuting Miss Becker for that crime today in the courtroom.
All right, thank you. I am going to allow it over objection. Any further redirect from the prosecution?
Yes, Your Honor. Detective Markowitz, how do we know where Avery Becker was at the time of the murder?
According to her cell phone account records, her cell phone was pinging to one tower that was very close to the area of Avery Becker's home, which is consistent with many things that we had found. And so she was found at the scene of the crime at the time of the murder, according to these cell phone account records that were taken at various times during March 6th.
Thank you. No further questions.
Any additional cross based on the redirect?
No, Your Honor.
All right, thank you. And that will conclude the testimony of Detective Markowitz. With that, for the prosecution, how would you like to proceed with your case in chief?
Your Honor, the prosecution calls the witness Alex Fuentes to the stand.
All right, thank you. All right, and Ms. Fuentes, I will just remind you that you are still under the witness oath that was given at the beginning of this proceeding. You may go ahead, counsel.
Good afternoon, Ms. Fuentes.
Good afternoon.
Let's start out with something easy. Tell us your name and spell your last name for the court reporter.
Alex Fuentes, Sifuentes.
Mr. Fuentes, tell us how old you are.
I'm 17 years old.
Are you in school?
Yes, I go to Colorado High School. I'm a senior.
What are some things you like to do at school?
I enjoy hanging out with my friends, and I'm also on the mock trial team.
Were you on the high school mock trial team last year?
Yes.
Tell us who your mock trial coach was last year.
Mackenzie Brackman.
And what was Coach Brackman like?
He was a really caring coach who was always helping his students. I really enjoyed working with him.
And did you have any friends on the team last year?
I was pretty good friends with Avery Becker.
And what was that friendship like?
Well, Avery and I really only hung out at mock trial practice and other related events, but we got along well and we pushed each other to be better students.
You mentioned spending time together at mock trial practice. Did you also have the ability to observe how Avery Becker and Coach Brackman interacted?
Yes.
How did they appear to get along?
Not very well. They seemed frustrated with each other.
What gave you that impression?
Objection, Your Honor, speculation.
Any response?
Your Honor, this is not speculation pursuant to Rule 701. This is the witness rationally based perception of the relationship between the victim and the defendant.
Any reply?
Yes, Your Honor, this is purely based on the witness's opinion, as they are not entered as an expert. Their opinion cannot be used to, be used as truth of the matter, therefore calling for speculation.
All right, I am going to allow it over the objection, so you may answer.
What gave you that impression that they did not appear to get along?
Well, Avery rarely came prepared for practice, and Coach Brackman was always getting on Avery's back about being more prepared.
Give us an example of a time when Avery was unprepared.
At the regionals tournament, it was pretty clear that Avery was unprepared, but still managed to win a Best Attorney award. But after the tournament at practice, Coach Brackman was really laying on to Avery about how unprepared she was.
How did Avery appear to react?
Avery looked so angry, you could just tell she was infuriated because she stormed out of practice.
What happened when she left practice?
I saw her grab a Sharpie permanent marker on her way out of the classroom, and then she went to the parking lot.
How did you know it was a Sharpie permanent marker?
I could just tell by the way it looked. It's very distinct. The Sharpies in that classroom look very different from other markers like dry erase markers.
And what happened in the parking lot?
Avery vandalized Coach Brackman's car by writing Worst Attorney Award with permanent marker on the car.
Did Coach Brackman know that Avery did that?
Yes, he caught her.
Mr. Fuentes, I want to talk now about what happened after the car vandalism incident. Did Avery Becker ever reach out to you after being kicked off the team?
Yes, she texted me.
Did you save a copy of this text conversation?
Yes.
And did you also provide that to Detective Markowitz in this case?
Yes, I emailed her a screenshot of the conversation.
Are you familiar with what's been marked as Exhibit 14?
Yes, I have a copy in front of me.
What is Exhibit 14?
It is a screenshot of the text conversation between me and Avery.
How do you know?
I recognize what we said to each other, and this is also how Avery's contact is saved in my phone.
Is Exhibit 14 in the same text conversation you had with Avery that day?
Yes.
Your Honor, the prosecution moves to admit Exhibit 14 into evidence.
All right, any objection, Ms. Proctor?
No, Your Honor.
I'm sorry, I didn't hear your response.
No, Your Honor.
All right, thank you. 14 will come in.
Thank you, Your Honor. What did Avery Becker text you?
Avery texted me and asked me to talk to Coach Brackman on her behalf to try and convince him to let her back on the team.
Did you agree to do that for her?
Yes, but I also let her know that I doubted anything would change his mind.
How did Avery respond to that?
Avery texted me back saying, well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house.
How did you respond?
I asked, what are you going to do to his house?
And what did Avery Becker tell you?
She texted back, I'm going to wait till he's at work, then break in and trash it. That'll show him.
At this time, Judge, the people request permission for my co-counsel to publish Exhibit 14 to the jury by sharing their screen.
That is granted.
Thank you, Ms. Brockler. And Your Honor, at this time, the prosecution has no further questions for this witness.
All right, thank you. Then I will turn it over for cross-examination. Ms. Proctor, you may go ahead when you're ready.
Thank you, Your Honor. Ms. Fuentes, you and the defendant have known each other for a while, is this correct?
Yes.
And you would even say that the two of you were best friends?
Yes.
But according to Ms. Becker, you and her were not best friends, not even a little bit. Could you please explain why she might think this?
I'm not sure. Avery was my best friend.
Objection, Your Honor, speculation. This question is asking the witness to speculate as to what Avery Becker was thinking.
Any response?
It is not speculation, because if the two were friends, I believe that they would have that communication with each other. And it would be hard to believe that one is best friends with the other when the other is not best friends with them.
I'm going to allow it, and as the witness already answered, I'll allow the answer to remain in the record. You may continue.
Thank you, Your Honor. On the day Avery got kicked off of the team, you were at the fry shack with the rest of the team. Is this correct?
Yes.
And you had been playing games on Ms. Becker's phone. Is this correct?
Yes, she gave it to me.
Your Honor, I would like to draw the jury's jury's attention to Exhibit 14 once again.
Okay.
Should I screen share, or because it's already been entered as evidence, do I need to be doing that?
It's up to you. If you would like to share it, that's fine. Or if you just want to ask your question, I know the jury has already seen it.
I will ask. Ms. Cifuentes, do you have the text messages open?
Yes.
Thank you. Could you please tell me what these are?
It's a screenshot of the text conversation between me and Avery.
So sorry. And you were told to brought in the phone that contained these text messages by Detective Markowitz, correct?
Yes, but silly me, I left my phone charging.
And you no longer have this phone, is this correct?
Correct, yeah. The battery was really old, and that's why I left it charging, and so I ended up getting a new phone.
You and Avery were often competing with each other during mock trial, yes?
Avery and I were teammates, and we were equally skilled.
I would like to ask that you please open your witness statement to page 28 and lines 29 through 31 as I read this portion aloud.
Objection, Your Honor. If the attorney is attempting to impeach this witness, they have not followed proper impeachment protocols. They've not given the witness any room to address their statement or clarify.
Okay. Ms. Proctor, would you like to respond?
Yes, if you could just give me a moment, I will include those proper impeachment rules.
Okay, you may have it as long as you need.
Thank you. Ms. Cifuentes, it is your exact testimony that you and Avery did not compete during mock trial and that the two of you were equally skilled?
Correct. Avery and I were not rivals.
And you recall giving a statement before this trial?
Yes.
And that statement was under oath?
Correct.
And you swore to tell the truth?
Yes.
And did you tell the truth?
Yes.
And your sworn statement was made on March 6, 2020?
Yes.
Which is much closer to the time of the death of Mr. Brackman than the time today?
Correct.
I would once again like to ask that you open your your trial documents to page 28.
Okay.
Now, this is a copy of the sworn statement that you gave prior to trial. Is this correct?
Yes.
And that is your signature on page 32.
Yes.
And you made this sworn and signed statement before a notary public who also signed this document.
Yes.
Could you please follow along silently as I read lines 29 through 31 on page 28? I spent so much time honing my craft that it sort of irked me when Avery would just come in and make things up as an examination went along. Avery was just coasting on good looks alone and likely won awards on that basis, not because of any real talent. Did I read that correctly?
Yes, but I never said that we were.
Yes, will be allowed at this time.
Any response?
I'm sorry, Your Honor, are you asking for my response?
Yes, if you have one.
Oh, yes. Well, the witness clearly did not mention anything about them being competitors, and the lines that were just read did not have anything to show towards that. So they can continue with their examination.
I would,
all right.
If I could, yeah.
Ms. Proctor, you may continue.
Yes. The portion that I read aloud was to inform the witness that she had made a statement prior to trial stating that she did not believe that she and Avery were equal in their talents and effort given, which she had stated in my questioning of her. And I just wanted to bring attention to that.
Okay, thank you. And the jury has now heard that. They will weigh it appropriately. You may continue.
Thank you. No further questions at this time, Your Honor.
All right, thank you. Mr. DeRose, did you have any redirect, sir?
No follow-up, Your Honor.
All right, thank you. With that then, Ms. Cifuentes is excused as a witness and we can continue on with the prosecution's case in chief. And for the prosecution, how would you like to proceed at this time?
Yes, Your Honor, thank you. We'd like to call Kyle Kuzak to the stand.
All right. Thank you. And it's Ms. Kuzak, is that correct? All right. I will simply again remind you as a witness that you are still under oath, as all the witnesses were placed under oath at the beginning of the proceeding. You may go ahead, counsel.
Thank you. Good afternoon, Investigator Kuzak.
Good afternoon.
Please introduce yourself to the jury, starting off by telling your first and last name, and spell your last name for the court reporter.
My name is Kyle Kuzak. Kuzak is spelled Kuzak.
Now, before we get into the details of your investigation, let's get to know you a little better. What do you do for a living?
I'm a crime scene reconstruction investigator, or a CSR as we are called.
What is a crime scene reconstruction investigator?
A crime scene reconstruction investigator is called onto a case once all of the evidence has been collected. We then sort through and ultimately come to a conclusion based on the facts of the case, scientific reasoning, and our training and expertise.
How does someone become a CSR?
To be recognized as a CSR in Colorado, you must be certified by the Colorado Bureau of Investigation.
And are you yourself certified by the Bureau?
Yes, I am.
How did you obtain your certification?
I went through extensive training in the field of crime scene reconstruction as well as investigation.
Where do you work as a CSR?
I work for the Denver Police Department.
How long have you been a CSR?
For the past 19 years.
And how long have you been doing that with DPD?
The last 3.
What type of crimes have you investigated?
I'm usually called on more complex crime scenes such as home invasions, armed robberies, burglaries, and other property crimes.
And are you the CSR in the murder investigation of Mackenzie Brackman?
Yes, I am.
As a CSR in this case, did you form certain opinions about how this crime was committed?
Yes.
What did you rely upon for these opinions?
I reviewed the police reports and I also looked at the exhibits. I visited the crime scene after it was processed. I visited with the crime lab and I reviewed the autopsy report.
Now, the training used to form your opinions, is this a type of training regularly accepted by the scientific community?
Yes.
And have you reliably applied those principles and methods to the facts of this case?
Yes, I did.
Your Honor, at this time, the people move to tender Investigator Kuzak as an expert in the field of crime scene reconstruction, pursuant to Colorado Rules of Evidence 702.
Any objection to that endorsement?
No, Your Honor.
All right, she will be so endorsed. Thank you. You may continue.
Thank you. Investigator Kuzak, before we get into your opinions on this case, let's talk about the evidence you relied on for those opinions. What evidence was significant in your investigation?
Well, I focused on 3 main areas of evidence, first being the ring videos, second being the photographs, and third being the autopsy report.
All right, let's break each of those down and talk about each one of those. Starting with the ring videos, what did you learn from the ring videos?
Well, from the ring videos, we learned that the suspect approached the Brackman residence on the afternoon hours of March 6, 2020. They tried to go through the front door. However, once they learned that was locked, they entered through the back sliding glass door.
Were you able to make any determinations about who the suspect was based on the ring videos?
From the videos alone, no. However, they matched the general height and build of the defendant.
In addition to the mask, was anything else hindering their identification?
Yes, the suspect was wearing gloves.
Turning now to the photographs of the scene, talk us through what you learned from them.
Well, first, there was a photograph of scuff marks by his back door, which I believe is Exhibit 18.
My co-counsel is showing you what has already been admitted as Exhibit 18. Awesome. What did that indicate to you?
This indicated to me that a struggle occurred by the back door.
Thank you, Ms. Brockler. In addition to the scuff marks, what other evidence was significant to you in that area of the house?
Well, in the dining area, there was a knocked over chair and a broken plate.
Why was that significant?
Well, because the dining area was only 5 feet away from the back door, it indicated to me that the struggle moved from the back door to the dining area, which was just outside the kitchen.
You mentioned the kitchen. What evidence did you find there?
Objection, Your Honor, leading.
Any response?
Your Honor, this isn't a leading question, doesn't imply an answer at all. I'm just asking what evidence you found in the kitchen.
All right, I will allow the investigator to answer what, if any, evidence was found.
You mentioned the kitchen. What evidence did you find there?
In the kitchen, there was a knife block missing its chef's knife.
Why was that significant?
Well, as there was a chef's knife found by the victim and a missing chef's knife from the knife block, these two indicated to me that the murder weapon came from the kitchen.
Describe the chef's knife that was found near the body.
It's an all-metal knife, and it measures around 12 inches in length. The blade is about 7.5 inches, and it's 2 inches across approximately at its widest point.
In addition to the knife block, what other evidence did you find in the kitchen?
There were blood droplets that began near the dining area and led to the front door.
Why is that significant?
This indicated to me that the victim was stabbed in the dining area, however, ultimately ended up by the front door.
Earlier, you mentioned an autopsy report. What did you learn from that report that you relied upon in your investigation?
Objection, Your Honor, leading question.
Any response?
Again, Your Honor, this isn't a leading question. I'm not inciting an answer. I'm just asking what the investigator learned from those reports.
All right.
Your Honor.
You may.
Your Honor, we have not heard anything about an autopsy report. Furthermore, we have not heard that this autopsy report aided Ms. Kuzak in her investigation, and his question implies that.
All right.
Can I respond, Your Honor?
You may.
In the past, in previous questions, Investigator Kuzak did mention an autopsy report. And in fact, that's why I'm asking this question, so we can learn more about the autopsy report and how it aided to our conclusions.
Okay. I'm going to ask if you will rephrase the question. I will sustain.
All right. In your past questions and your answers, you mentioned an autopsy report. Did
Correct.
you learn from the report?
Oh, yes. The medical examiner determined that the cause of death was penetrating trauma to the thoracic aorta.
What does that mean?
Well, essentially, the victim was stabbed once. However, this injury turned to be fatal.
Objection, Your Honor, this is a lay opinion about medical expertise.
Any response?
Your Honor, we did tender Investigator Kuzak as an expert in the field, so she is allowed to testify to her opinions.
Okay, I am going to allow it over objection as I have certified her in crime scene reconstruction. I do think her opinion on the method is within her expertise, so I will let her answer.
What does that mean?
So essentially, the victim was stabbed only once. However, this injury turned to be fatal.
Did the medical examiner determine why this one injury was fatal?
Yes, essentially, when the knife was inserted into the victim, it slowed and obscured any internal bleeding. So once the knife was removed, the victim would have lost a significant amount of blood, leading quickly to death.
Did you have the knife found at the scene tested for DNA and fingerprints?
Yes, however, the only DNA and fingerprints found belonged to that of the victim, which wasn't that surprising.
Why is that not surprising?
Well, as I mentioned before, the suspect was wearing gloves, so there's no way that any of their DNA could have gotten on the crime scene.
Given all of that, what is your opinion on how this crime occurred?
Well, the physical evidence lead to only one conclusion. That is that the victim was alerted via ring security system that the intruder was approaching the house. The victim then grabbed a knife and confronted the intruder at the back door. A scuffle occurred over the knife in which the intruder gained possession of the knife and stabbed the victim in the upper back shoulder area. The victim then removed the knife and bled quickly to death.
How did you reach that conclusion?
Well, it's obvious this happened because there was a missing knife in the knife block. There was an open drawer in the kitchen showing that the victim was looking for a knife. Not to mention there was a knocked over
Your Honor, asked and answered.
Any response?
Your Honor, I'm just asking the witness how she was able to reach her conclusion that she just mentioned, basically explaining what type of evidence she used and how that aided her in her conclusion.
Any further response or reply?
Yes, Your Honor, Ms. Kuzak has already testified about the physical evidence she found. She's only repeating her previous answers to questions.
Okay. You may.
Again, Your Honor, she's further explaining how that evidence was specific to coming to her final conclusion, and we haven't mentioned her final conclusion yet.
All right, I am going to allow the question as it is aimed toward the final conclusion and how these different pieces tie together. So you may continue with your answer, Investigator Kuzak.
Thank you.
How did you reach that conclusion?
As I was saying, there was the open knife drawer, there was a missing knife from the knife block, not to mention there was a knocked over chair, a broken plate, and scuff marks by the back door, which all indicate a struggle.
Why does it matter who introduced the knife in the struggle?
As it is clear that the intruder did not introduce the knife into the struggle, it shows that they did not enter the home with the intention of committing a murder, but more so entered the home with the intention of committing a property crime, like a burglary, but was surprised to see the homeowner there.
Thank you. No further questions, Your Honor.
All right, thank you. I'm going to turn it over now for cross-examination. Counsel, you may begin when you're ready.
Thank you, Your Honor. Good afternoon, Ms. Kuzak. My name is Sydney Dragovich, and I'm going to ask you some questions about this case. You said that you visited the scene of the crime, correct?
Yes, after it was processed by the crime lab.
Yes, and it seemed fairly simple to you.
Oh, yes.
But we can't actually look at the photos of the blood trail you mentioned, isn't that right?
I believe so. I think I heard about it being corrupted. However, I was able to look at it just okay, and I passed it off to the next person who had to look at
They were
it.
lost by the police department?
Huh?
The photos, they were lost by the police department.
Oh,
A yes or no answer will be all right for this question.
as I was saying, I think they were corrupted.
So that is a yes to my answer, to my question?
As I said before, I don't really know what happened. I saw them and passed it off to the next person who had to view them. So, I heard it was.
So yes,
Sorry?
you heard that it was corrupted. It is your understanding that the photos were corrupted?
Objection, Your Honor. Can we let the witness answer? Because I think this answer doesn't really pertain to her specifically.
Okay. I will let the witness answer if she knows if the photos were corrupted.
Thank you. As I was saying, I was able to view the photos perfectly. I handed it off to the next person who had to see them at the crime lab. And from what I heard, they were corrupted. However, I have no idea how that happened or how that pertains.
Thank you. In your statement, the only evidence you mention against Avery Becker is that she is the same general size as the masked person on the ring cameras, correct?
Correct.
And you said that some scuff marks on the kitchen floor indicated a struggle.
Yes.
And the knife slot, or the empty slot in the knife block led you to believe that the knife found in the victim's body came from that knife block.
Of course, it was a simple trail.
And the knife found in the victim's body was a different brand than the other knives in the knife block?
Yes, it's not uncommon for people to replace knives with a different brand when they lose a knife. I mean,
different brand than the knife said in the knife block.
Yes, however, it's not uncommon to replace knives with different knives.
There wasn't as much physical evidence as you would have liked, was there?
Well, there never really is. I'd always like more evidence, but I would say it was okay.
So is that a yes or no to my question? I'm sorry.
Well, I would always love more evidence. So I guess in this case, yes, but I was able to work with it.
And nowhere in your statement do you mention checking the victim's notification settings for his Ring doorbell.
No, that's simply not my job. I take the evidence that was collected by the police and reconstruct the crime scene.
And you received no evidence about the victim's notification settings. You don't mention receiving any evidence in your statement, do you?
No, I didn't receive that kind of evidence.
Nor did you receive any evidence regarding whether or not the victim had his phone on him when the intruder approached the house.
I do not believe I received that kind of evidence.
Thank you, Your Honor. No further questions.
All right, thank you. Any redirect?
No, thank you, Your Honor.
All right, then that concludes the testimony of Investigator Kuzak. And with that, how would the prosecution like to proceed?
The prosecution rests, Your Honor.
All right, thank you. And with the prosecution resting, then I will turn it over to the defense to present your case. And on behalf of the defense, how would you like to begin?
Your Honor, the defense calls Professor Blake Van Owen to the stand.
All right, thank you. And Professor Van Owen, I will simply also remind you that you remain under oath, as all the witnesses were given oaths at the beginning of this proceeding.
Yes, Your Honor.
All right, you may go ahead, counsel.
Will you please state your name for the court?
My name is Professor Blake Van Owen.
Professor Van Owen, what is your job?
I've been a professor at CU Denver for 5 years now, teaching on police practices and social justice. I obtained my master's in criminal justice.
And did you have any other occupations before becoming a professor?
Before that, I was a school resource officer, a private investigator, and a private security guard while teaching on police practices at Community College for the Rockies. I originally started out as a police officer with the Aurora Police Department.
And have you testified as an expert witness before?
Yes, many times. I've been accepted as an expert witness in the U.S. District Courts for the districts of Colorado, Kansas, and Arizona, as well as the state courts for the states of Colorado, Wyoming, Nebraska, and New Mexico.
And have you been accepted in any areas relevant to this case?
Of course. I've been accepted as an expert in crime scene reconstruction 8 times, in cell tower analysis 5 times, and in general police investigation tactics 12 times. I've been retained as a consultant in over 100 cases.
And what was your role in this case?
I was retained by the defense to review the police reports and the crime scene reconstruction conducted by Kyle Cusack, as well as the cell tower analysis and the exhibits that Detective Markowitz prepared.
Your Honor, the defense offers Professor Blake Van Owen as an expert witness in the fields of crime scene reconstruction, cell tower analysis, and general police investigation tactics pursuant to Rule 702.
All right, thank you. Ms. Brockler, any objection?
Yes, Your Honor, a brief voir dire.
You may.
Good afternoon, Professor Van Owen. I want to start by talking about your experience, and I want to go through some of the things you've already talked about, so bear with me. I just want to make sure we get this right.
Of course.
First, you have a bachelor's degree from CU Boulder.
Correct.
In English.
Yep, in English.
After graduating, you joined the Aurora Police Department.
Mm-hmm.
Where you
Yes.
worked, that's a yes, correct?
Yes, that's great.
Where you worked for a total of 9 months, is it?
Yeah, 9 months.
And does that include the months you spent in the police academy?
Mm-hmm.
Is that a yes?
Yes.
In a classroom?
Yes.
Fair to say you were never assigned as a lead investigator on a homicide?
Sure.
Or burglary?
Yes.
Or frankly, in any case?
Yes.
You never supervised any other officers in a sergeant capacity?
No.
You never filed a case as a detective?
No.
Or, unlike Detective Markowitz, testified as an expert when you were a police officer?
No, however, I have a lot of experience. I've testified in over 100 cases, and I don't see what would make this case any different than all of the others.
Professor, I'm just asking if you testified as an expert during your time as a police officer, which you said no to. You never completed any other advanced training through the police department?
No.
Or any training at all on police tactics?
No.
So when it comes to police procedure and tactics, your entire foundation is based solely on your 9 months as a rookie cop.
I currently teach a class on police procedures, and I regularly testify as an expert in police procedures. So if you're insinuating that I am not experienced or qualified enough to do that, I would disagree.
Detective, again, you were only a police officer for 9 months?
Objection, Your Honor, asked and answered.
Okay, I will sustain. You may continue with voir dire.
Your entire foundation, though, on your opinion of police procedure and tactics, is based on your experience as 9 months as a rookie cop.
Objection, Your Honor, again asked and answered.
Any response?
Your Honor, I'm just getting a solidified answer because, again, while she might teach a class, we don't know any more training or things like that that she has on police procedure and tactics. We don't know what education went behind her training or teaching this class.
All right, I will allow it briefly. You may answer, Professor.
Can you repeat the question?
So when it comes to police procedure and tactics, your entire foundation is based solely on those 9 months you spent as a rookie cop.
Whatever, yes.
The majority of which was sitting behind a classroom in a desk.
Objection, Your Honor, asked and answered. Counselors repeatedly asking questions that have already been answered.
Any response?
Your Honor, again, I'm just asking about the majority of her 9 months as a rookie cop, whether that was during her training, which she hasn't responded to yet. She only said that she did go through training.
Okay, I will allow it. You may answer.
The majority of your 9 months, Professor, was sitting in a classroom behind a desk, correct?
We get a lot of hands-on experience too. It's not all behind the desk.
Professor, I asked for the majority of that was in a classroom behind a desk, though?
Sure, the majority of the time was behind the desk.
Judge, the prosecution objects to this witness being an expert, accepted as an expert in the field of cell data recovery and police procedure and tactics and general investigation. First of all, this witness has zero training in police tactics and procedure other than basic police academy, and we certainly don't let every police officer testify as an expert just for completing the police academy. Just because this witness teaches a class at a local school on police procedure does not mean that they are an expert in the field, or frankly, that they have any knowledge on the subject at all. When it comes to crime scene investigation and reconstruction, this witness is not certified as a crime scene reconstructionist, and they have no training in the field from the Colorado Bureau of Investigation, and they have not worked as a CSR for any police department, and we have not heard about any training in this field at all.
All right, thank you. Any response to the objection of the endorsement?
Yes, Your Honor. Professor Blake Van Owen's extensive experience as a police officer, private investigator, school resource officer, and professor in all of these areas has not only given her the credibility to be a professor on police procedures, but to serve as an expert in these fields countless times, being a consultant in over 100 cases. Her education and experience combined are more than enough qualifications to be held as an expert witness pursuant to Rule 702.
Anything further, Ms. Brockler?
Again, Your Honor, she was only a police officer for 9 months, and we don't know what it takes to teach at a community college about police procedure. We've heard nothing on that background. We've also heard nothing on her background as an investigator or a crime scene reconstructionist, because she does not have a background in either of those two fields. So I'm going to keep my objection.
All right, thank you. Well, I am going to allow the endorsements in the 3 different areas over objection. You may continue with your questioning, counsel.
Thank you, Your Honor. Professor Van Owen, in your expert opinion, did you reach any conclusions about the police investigation for this case?
Yes. In my expert opinion, the police investigation was rushed, negligent, and incomplete. I ended up needing to do my own partial investigation in areas I feel the police neglected.
And you said that you started out as a police officer. Are you still an officer?
No.
And how long were you a police officer for?
Again, 9 months.
And why did you leave?
There was an incident in which I injured a young woman of color during her arrest. I was cleared professionally out of any wrongdoing, but I couldn't really clear myself, if you know what I mean. For me, it just crystallized a sense that things need to change. The young woman and I ended up reaching a confidential settlement, and although that does not erase what I did, it wasn't.
Your Honor, relevance.
Any response?
Your Honor, as opposing counsel was clearly just emphasizing her time as a police officer, I would like to clarify why Professor Van Owen was a police officer for a relatively short time.
Any reply?
Yes, Your Honor. Well, it's fine that she's mentioning why she left the police department. We certainly don't need a narrative about her history between her and this woman and the settlement that they reached or any of that.
All right, I'm going to sustain. You may continue on, counsel.
Thank you, Your Honor. You said that the police investigation was rushed. What do you mean by that?
So to me, it's clear that they went for the easiest conclusion, but easy leaves us with significant doubt as to who actually committed the crime. I honestly believe that a more thorough investigation should have been conducted before impaneling a jury.
And do you agree with Kyle Kuzak's theory of how the victim was stabbed?
Not at all. I've reviewed autopsy reports and crime scene reports from hundreds of stabbings, and the more likely theory is that the victim was stabbed in the back while sitting down.
Professor, will you please turn to what has been marked as Exhibit 21 in your case materials?
I have it open.
Do you recognize this photo?
Yes, this is it's a photo of how I believe the knife to have been held in this stabbing, and it's different from how people believe most knives are held in stabbings, so I find this photo helpful in explaining this technique to others.
Your Honor, at this time, the defense offers Exhibit 21 into evidence.
Any objection?
No, Your Honor.
All right, 21 will enter.
Thank you. Let the record reflect I'm screen sharing what has been entered into evidence as Exhibit 21.
It will reflect.
Thank you, Your Honor. My apologies. My computer is being okay.
That's all right. And if you're not able to screen share it, you can certainly ask the witness if they have their own copy and can describe what's in front of them. I think all parties have copies.
Okay, my apologies. My computer's having technical difficulties. Professor Van Owen, can you describe how this knife grip looks?
Right, so it's a picture of a knife and it's held upside down, which is obviously different from how most people believe knives to be held in stabbings. And you can see the hands aligned on the knife grip in the way that the knife was intended for the fingers to be aligned.
And can you explain your reasoning that led you to conclude that this was how the knife was held?
Of course. So the knife nicked the victim's aorta at a downward angle.
Objection, Your Honor. Improper expert testimony. This expert's not an expert in anything medical, only in investigation and police procedure and tactics. I don't understand why she's opining on how a knife is being held.
Any response?
Yes, Your Honor. Just as Ms. Cusack was allowed to talk about the autopsy report she reviewed, Professor Van Owen has already said how she reviewed all materials for this case. And so we ask that she be permitted to talk about it the way that Ms. Cusack was.
Your Honor.
You may.
Yes. Ms. Cusack was not coming to a medical opinion with her conclusion. She was simply restating what she learned from the autopsy report that contributed to her investigation. However, here, this witness is coming to a medical conclusion as what happened in the autopsy report was caused by somehow holding a knife differently. That takes medical expertise.
All right. I'm going to allow the witness to answer over objection as to how she believes the knife entered the body based upon her investigation she was performed. This is not a medical opinion. She is not a medical expert, so it won't be accepted as medical expert testimony, but as her expert opinion based upon her review.
Thank you, Your Honor.
You may answer.
So like I was saying, the only way for the knife to nick the victim's aorta at the downward angle that it did is if the intruder was significantly bigger than the victim. However, seeing as the autopsy and the ring cameras prove otherwise, I find it much more likely that the victim was stabbed in the back again while sitting down.
And does the shape of the knife used in this case align with your theory about the stabbing?
Yes, as you can see in the photo, the knife grip is aligned in a certain way for the user's fingertips to align a certain way, which would cause it to actually be more awkward and more uncomfortable to hold it in the way that most knives are held in stabbings. So holding it upside down, so to speak, would have actually been much more natural in this case.
And is it possible that the victim was caught by surprise even with his ring cameras?
Yes. Even likely. I own a Ring camera myself, and it is indeed possible to turn off the notifications. But even if those notifications were turned on, there's no way to say if he actually checked the notification. Regardless, it seems as though Detective Markowitz failed to check the victim's Ring account settings, so we'll never know if those notifications were turned on or not.
And speaking of technology, did you investigate Ms. Cusack's theories about the cell phone towers?
Yes, and I would like to make one thing clear. Cell towers do not accurately or reliably prove the location of a user of a phone at any given time on their own. Cell phones are designed to connect to the cell tower with the greatest signal. That's not always necessarily the nearest tower. And cell towers, they cover a relatively large radius, 6 or 7 miles, so they can't pinpoint an exact location.
And is there a way to track the phone by GPS?
That's only possible if we have the real tangible phone, but we don't. All we know is that at the time of the murder, Avery's phone pinged a cell tower in the general area of the victim's house. If Detective Markowitz had retrieved cell tower records from maybe before or after that time, we might have a better general idea of where Avery was or if she had her phone at all. But like I said, this investigation was rushed and very poorly handled.
And were there any other cell tower records that Detective Markowitz failed to retrieve?
I mean, it's ridiculous that she only looked at the cell tower records related to Avery Becker's phone. Any detective whose mind isn't made up before examining this would have looked at all the cell tower records related to all the phones in the general region of the victim's house. But I mean, she didn't even look at the records related to Taylor Perkins' phone, which is a pretty big mistake considering the two were together the entire day. Thankfully, I looked into it myself.
And did you discover anything significant?
I did. For every caller text that Avery's phone received, there is a corresponding caller text sent from Taylor's phone. Most of these come from antenna 2 of Tower 1191, which covers the mall. This corresponds with the two of them going to the mall to search for Avery's missing phone that day.
And was Ms. Kuzak correct for concluding that there was a struggle?
Well, the evidence she uses to prove this isn't very helpful. For example, an open drawer. Okay, he forgot to close the drawer. Big deal. Broken plate. It was a stabbing, right? It could have fallen off the table then. I mean, it's just, and the scuff marks, like those literally don't prove anything. It can't be used.
Can you elaborate on why the scuff marks are unreliable?
Yeah, I mean, if you look at the picture of the scuff marks, first off, they're so close together, they look like a rolling cart could have made them. And you can see brush marks. I mean, they could have been painted on the floor, and we can't carbon date scuff marks. For all we know, they could have come to be 5 years ago. We'll never know when those came to be.
Did you review the screenshots of the text messages that Alex Cifuentes sent to the police?
Yeah, I did. And I am appalled that the police would simply allow Alex to send them screenshots of the text messages. Everyone knows that you can easily screenshot text messages or you can easily doctor screenshots of text messages on any smartphone. Furthermore, the Denver police have a forensic software called Celebrate that allows them to download the contents of any cell phone. If the police had any desire whatsoever to conduct a thorough investigation, they would have used the tools they quite literally had at their fingertips.
Did you find any other potential suspects?
Yes, actually, I listened to a recording of a trial that Mr. Brackman defended a client in. Try as Mr. Brackman might, the chips were stacked against his client, Jonathan Rollins. And on the portion of the recording that I listened to, as Jonathan Rollins was being escorted out of the courtroom, he threatened Mr.
Objection, Your Honor, hearsay.
Any response?
Yes, Your Honor. Professor Van Owen is not offering this up for the truth of the matter asserted. She's only accurately reporting every step of her thorough investigation.
Any reply?
Yes, Your Honor. Professor Van Owen is quite literally offering this for the truth of the matter, because in order for us to believe that Jonathan Rollins had a motive, we have to believe that what he said in that recording was true.
Anything further from defense?
Yes, Your Honor, that's actually untrue, what opposing counsel just stated. As I previously said, this was just one step in Professor Owen's investigation, and as you will see, it prompted her to investigate Mr. Rollins more.
All right. Anything else, Ms. Brockler?
I would, again, just restate that if it's true what's said in the audio, that would cause her to keep moving forward, believing that Jonathan Rollins had a motive. Therefore, we have to believe that what he said was true. That's hearsay.
All right. I'm going to sustain the objection and ask you to move on, counsel.
Yes, Your Honor. Did you look into Mr. Rollins more?
I did. It turns out Mr. Rollins has a daughter, Blair Rollins, who was a senior at Colorado High School last year. I mean, the recording obviously wasn't enough to prove anything, but it did prompt me to investigate. Blair was present at her father's trial and actually testified on his behalf.
And did your investigation uncover any other evidence incriminating Blair?
Well, I looked through the CHS yearbook and I found that Blair and Avery have a similar build and body shape, but also Taylor and Avery both confirm this. I also found out that that Blair and Alex were friends. I'll get to that more in a little bit. However, Blair mysteriously disappeared after graduation, and no one, myself included, has been able to locate her. However, it's no shock that the police didn't even bother to investigate Blair. All in all, someone whose father was sentenced to life in prison seems like a much bigger murder suspect than someone who is simply cut from a school mock trial team. This isn't rocket science.
And what are your theories surrounding Blair Rollins?
Right, so like I was saying, Blair and Alex were actually friends. Since it's likely that Alex already took the time to create fake text messages that would implicate Blair, it's also likely that—
Objection, Your Honor. This is completely speculation. She's just making up theories.
Any response?
Yes, Your Honor. Professor Van Owen is not speculating about whether or not the texts were faked, but she is only telling us that her analysis and investigation suggested that to be a likely possibility.
All right, I am going to allow the testimony as a possibility based upon her investigation.
Thank you, Your Honor. Professor Van Owen, would you like me to ask the question again?
Sure.
What are your theories surrounding Blair Rollins?
So Alex and Avery were friends. It's likely Alex took the time to create fake text messages that would implicate Blair. It's also just as likely that Alex, helped Blair steal Avery's phone to frame Avery for murder. Also, records show that Blair was absent from school on the day of the murder. We also know that Taylor and Avery were absent, but they were at the mall. So it's also likely that the day before the murder, Blair stole Avery's phone, took it to the crime scene, and framed her there.
And do you have any support for this second theory?
We know that Avery was at the Fry Shack on the evening of March 5th, 2020. We also know that the Fry Shack is a very popular place for CHS students to go. So it's just as likely that Blair was there that day, stole it there.
Professor Van Owen, in your expert opinion, what did your review of the police investigation and your own partial investigation reveal?
This investigation was rushed. It screams, I made up my mind before I investigated anything and found evidence to support my premature assumptions. This is the easy way out. If the investigation had actually been conducted thoroughly and carefully, we might have the real murderer on trial today, not Avery Becker.
Thank you, Your Honor. No further questions.
All right, thank you. I will turn it over now for cross-examination. Ms. Brockler, you may go ahead when you're ready.
Professor Van Owen, you just testified to a whole bunch of opinions, but before we get to your findings in this case, it's important to look at why you're here today. You were hired by Avery Becker, correct?
Yes.
To offer opinions on behalf of the defense?
Yes.
And you were paid quite well for those opinions.
Yeah, I mean, that's a very, very general, very average amount for an expert witness like me, especially in a murder case.
And you were paid quite well for your testimony today, too.
Yeah, doesn't give me bias. I'm just doing my job.
In fact, you're on the clock right now.
Yeah.
Let's talk about your rates. You make $225 an hour for your research.
I do.
And you get paid even more than that to testify to your opinions in trial.
Objection, Your Honor. Relevance.
Any response?
Your Honor, the payment of this client to offer opinions today on behalf of the defense is very relevant to any bias you might have in this case.
All right, I'm going to overrule the objection.
You get paid even more than that to testify to your opinions in trial today, correct?
Yeah, I mean, I think that's a very normal rate for someone like me.
So let's talk about how much Ms. Becker paid you. Or let's talk about the opinions that Ms. Becker paid you so much for, pardon me. You would agree it's important to consider all of the evidence found at a crime scene.
Correct.
And not place any emphasis on one piece of evidence over all others.
Correct. I think it's important to consider everything.
The most basic principle of being an investigator is to never make assumptions, never assume.
I mean, I think it's important to follow leads.
Detective, as you say, investigations 101, never assume.
Well, if there's a viable theory, I think it's important to follow that lead. So I think it's important to consider everything, yes.
Detective, I'm just using your words today. Investigations 101, never assume.
I know to never assume, but I think it's important to investigate everything.
Now, you and Detective Markowitz agree that someone, an intruder, entered the home unlawfully.
Correct.
Where you two disagree is whether the victim was alerted to the intruder or not.
Yes.
You believe that the victim was not aware of the intruder before being stabbed.
Yep, I do. And if you would like to talk about that some more, I am totally—
Professor Van Owen, you'll have a lot of time to articulate your opinions on redirect. I'm just asking for a yes or no.
Yes, I believe that he was caught by surprise.
Even though Detective Markowitz found scuff marks by the door indicating a struggle.
Yeah, I don't think those scuff marks can be used as evidence.
Your next opinion is in regards to the murder weapon. First, you believe that the intruder brought their own knife because they went to the victim's home with the intention of killing the victim.
Correct.
You assume this because the knife that was used to stab the victim is a different brand than the other knives in the knife block as seen in Exhibit 8.
Not only a different brand, but also an entirely different make and model, an entirely different style.
So yes, Detective.
Yeah.
even though the most basic principle of investigation, as you say, is to never assume.
Objection, Your Honor, asked and answered.
I will sustain.
Let's see what the evidence tells us from the scene. I'm showing you what's already been admitted as Exhibit 10. My co-counsel will be presenting their screen shortly to show you Exhibit 10. You would agree, Professor, that this intruder does not have a knife in their hands.
Okay, just because you can't see a knife in his hands does not mean he didn't have a knife on his person.
You could assume it is in his pocket.
I mean, it could be anywhere.
But as an investigator, you should never assume, correct?
Objection, Your Honor, we have already covered this topic more than sufficiently.
Okay, and I think the witness has answered not to assume, but you may continue on, counsel.
How many inches was this knife in total length?
You know, I can't quite remember. Can you refresh my memory?
Professor, you're here as the lead detective or investigator on the defense side, and you can't tell us the length of the murder weapon?
Objection, Your Honor, argumentative.
Okay, I'm going to allow the question. If the witness doesn't know, then counsel can rephrase and give the length of the knife in the next question.
Professor, if both Detective Markowitz and Kuzak's report indicate that the knife is 12 inches, you would agree with that?
Yes.
Okay, so that's this big. I'm using my hands to demonstrate 12 inches.
Okay, yeah, that's 12 inches.
You would
I
agree
have
with that?
a perfect visual of 12 inches in my mind right now.
So you want the jury to believe that the intruder this big, or was carrying a knife this big somewhere on their person or in their pocket?
It's very possible, yes.
But even if the knife was somehow magically in a gigantic pocket, of course there would have been DNA found on the knife, and you would agree that that didn't happen here.
I mean, could have been wearing gloves.
But you would agree that there's no DNA on the knife, even though he, as you assume, could be carrying it on his person?
Yeah, there was no DNA found on the knife. I'm not sure where you're going with this.
Let's talk about some other things that didn't happen in this investigation. Part of your opinion in this case is listing all of the things that Detective Markowitz could have done but failed to do.
Right. Proof that it was a rushed investigation.
Right. You believe it was rushed, that it had all the hallmarks of I made up my mind at the get-go, and I just found the evidence that supports my conclusion.
Right.
For example, you believe that Detective Markowitz should have pulled the cell tower data for Taylor Perkins' phone.
Yeah, he looked at a very limited time window, and we might have had a better general idea of where Avery's phone was, or if she even had possession of her phone, if he looked at records from before or after the time of the crime.
So that's a yes, Professor.
Yes.
Because that would show us where Taylor Perkins' phone was the day of the murder.
Not necessarily. It just would have provided a bigger general idea.
You also believe that Detective Markowitz should have pulled the cell phone records for Avery Becker's phone from the day before the murder.
Yeah.
To confirm where Avery Becker's phone was the day before.
Correct.
But isn't it your opinion that cell phone records are unreliable?
I figured this would come up. Cell towers are evidence.
You are going to have more than enough time to answer this on direct or redirect. It's just a yes or no. You believe that cell phone records are unreliable, correct?
Yes. Sure.
So the cell phone evidence is only reliable when it supports your conclusion then, Professor?
Objection, Your Honor, argumentative.
Any response?
Your Honor, I'm on cross. I'm allowed to make my argument.
I'm going to allow the question. You may answer if you're able, Professor.
Can you repeat the question?
So the cell phone evidence is only reliable when it supports your conclusion, Professor.
No, that's not what I'm saying at all. Again, cell towers are evidence. It's just a matter of how strong. My cell tower evidence corresponds with the rest of my theories, and so it's a lead that the police should have followed before impaneling a jury.
Even though the cell tower evidence Detective Markowitz uses also corresponds with his theories.
Right, but one ping around the general area of the victim's
Thank you, Professor. In any event, it's your conclusion that Avery Becker lost her phone at the mall.
Yeah, they went to the mall to discover where they left the phone.
And you reach this conclusion based on what Avery Becker told you, the person accused of committing this crime.
Both Taylor and Avery confirm this, as well as the text messages are sent from antenna 2 of tower 1191, which covers them all.
You assume that they are telling the truth.
Well, yeah, they were under oath and they signed. So yes, I'm assuming they told the truth.
But even still, you believe you uncovered another person with an even stronger motive to kill Mr. Brackman.
Yeah.
A man by the name of Blair Rollins.
Yes.
Because Mr. Rollins' father was convicted of murder and Mackenzie Brackman was the attorney who represented the father at trial.
Oh gosh, don't even get me started on this.
Professor, is that a yes?
There is more evidence than that.
Counsel is not allowing my witness to answer the questions.
Okay, I'll allow the witness to answer. The witness just said there's more evidence than just that, but I will let Cross continue.
Blair Rollins wanted revenge against Mackenzie Brackman, correct?
Correct.
You believe that Blair Rollins had ample opportunity to commit this crime?
Yes.
Because he was a student at Colorado High School?
Yes.
He was friends with Alex Cifuentes?
Yes.
He matches the build and body shape of the suspect in the ring video?
Correct.
And he was absent the day of the murder?
Correct.
But Professor Van Owen, isn't it also true that Avery Becker was a student at Colorado High School?
Yeah, she was a student at Colorado High School. I think everyone
Avery
knows.
Becker was also friends with Alex Cifuentes.
I mean, that whole theory is, I mean, we don't really know.
Is that true?
Yes.
And Avery Becker also matches the build and body shape of the suspect in the ring videos.
Meaning that that suspect also resembled Blair Rollins, is what you're saying.
I'm asking if Avery Becker matched the build and body shape of the suspect in the ring videos. Is that correct?
Avery matches Blair, Blair matches the ring videos.
So that's a yes, Professor?
Yeah, that's a yes.
And Avery Becker was also absent from school on the day of the murder.
Right, but Taylor and Avery, we have confirmation that they were at the mall.
And Professor Van Owen, isn't it true that Avery Becker wanted revenge against Mackenzie Brackman?
I mean, yeah, but she was just in the heat of the moment.
Professor,
We'll testify soon.
So that's a yes, she wanted revenge?
Yeah, but I didn't think she intended to murder.
Thank you. No further questions.
All right, any redirect, Ms. Dragovich?
Yes, Your Honor. Professor Van Owen, first of all, can you explain why, although Blair and Avery have their similarities, why Blair is the much more likely suspect?
Yeah, so again, we've already stated that Blair has a similar build and body shape to Avery. Blair was absent from school that day. Blair mysteriously disappeared from graduation. Blair's father was sentenced to a life in prison because of Mr. Brackman defending him in court. So I think that someone who watched her father get put away for life is a much bigger murder suspect than someone who was simply cut from the school mock trial team. It's not rocket science.
And why is the way that Detective Markowitz used the cell tower records unreliable?
Well, cell tower records, they cover a relatively large radius, 6 or 7 miles. That can't pinpoint an exact location. Also, in a metropolitan setting like this, it's easy for phones to jump from tower to tower in order to reach the best signal. So yes, these are evidence. It's just not strong enough to prove a murder.
Thank you, Your Honor. No further questions.
All right, thank you. Any cross based on those redirect questions?
No, Your Honor, thank you.
All right, then Professor Van Owen may step down from the virtual witness stand. And for the defense, how would you like to proceed with your case?
Your Honor, we would like to call Taylor Perkins to the stand.
All right, thank you. And for witness Perkins, again, I will remind you, as I did with the other witnesses, that you are still under oath. All right, you may go ahead when you're ready, counsel.
Thank you, Your Honor. Ms. Perkins, could you please spell your name for the court?
My name is Taylor Perkins. My last name is spelled Perkins.
Thank you. And what is your relationship with the defendant?
She was one of my best friends in high school, and we were on the mock trial team together.
And how would you describe Ms. Becker?
I would describe her as a very spontaneous person, although people will say that although she did come late and unprepared to most things, she was able to make up for that.
And do you know Alex Cifuentes?
Yes, I do. She was a year below Avery and I in high school.
And knowing the two of them, how would you describe their relationship?
From my perspective, I would describe Alex and Avery as sort of rivals, although Alex will tell you that her and Avery were the best of friends. From my perspective, I just did not see that.
And could you describe the relationship you witnessed between Avery and Coach Brackman?
Yes, again, from my perspective and from an outer point of view, a lot of these students on mock trial could tell that Avery and...
Objection, Your Honor, speculation.
Any response?
Your Honor, this is not speculation. I am clearly asking for the witness's opinion on the matter, in the sense that she was constantly around the two and had a very good observation and sense of their relationship.
May I respond?
You may.
Your Honor, this is not the witness's opinion, as the witness does not know the inner thoughts of the other mock trial team members. So she's not giving her opinion. She's simply stating what she believes they would think, which is clearly speculation.
All right. You may, if you'd like to.
Yes. Your Honor, this clearly is not speculation, because while she is giving her own opinion, she is not inciting what the other two may think. She is simply stating what she has viewed their relationship as for the past few years.
All right, thank you. I will allow the witness to answer based upon her own perceptions.
Again, as I was stating, Mr. Brackman and Avery kind of had a little feud going on. You could tell because every time that she came unprepared or late to practice, you could almost see the steam coming out of his ears.
Do you know why this feud began?
Yes, as I stated before, Avery attended mock trial either unprepared or late, and it irked him to no end that although she was late and unprepared, she was still better than half of our team.
Could you please share what you were doing on March 6, 2020, the day of the murder?
Yes, so Avery and I decided to carpool to school, and once I got in the car, we realized that her phone was missing. So we retraced our steps from our girls' day the day before and went to the mall and ended up at the Fry Shack.
Where was the last place that you saw the defendant's phone before it went missing?
On March 5th, 2020, we had ended our girls' day at the Fry Shack, where we had run into some of the other members of the mock trial team, and Avery had rushed off to the bathroom where she left her phone on the table, which I remember thinking was kind of weird because it was almost like a third kidney to her. But I realized that she was upset, so she probably wasn't thinking clearly. But that's the last place I saw her phone.
Thank you. And after being unsuccessful with your search around the city, did you use any other methods to try and find Ms. Becker's phone?
Yes, we were going to try find my iPhone, but then we realized that I have an Android. I guess we could have looked on the cloud, but that thought hadn't occurred to me.
And how long would you say the search for Ms. Becker's phone took?
Seeing as we retraced our steps from the day before and we were in no rush the day before to get home, I would like to say that it was around the whole day that we spent searching for her phone.
And when did you find out about the death of Mr. Brackman?
I remember Avery and I were at the Fry Shack to ask some of the employees if they had seen her phone from the day before on March 6th, or on the day before. And we had run into the mock trial team again, where they stated that Mr. Brackman hadn't shown up to practice and he wasn't returning any phone calls or text messages. So because of the 15-minute rule, they left. And that's when I discovered, and a few hours later, I discovered that he had been murdered.
And to clarify once more, you were with the defendant the entire day?
Yes, I was.
Thank you. No further questions, Your Honor.
All right, thank you. I will turn it over for cross-examination. Mr. DeRose, when you're ready, sir.
Yes, Your Honor. And may I ask before we begin if we could get a time check of how much time's left on cross-examination for the prosecution?
Sure. Can the timekeepers either put that into the chat or unmute yourself and let us know? I have 7 minutes and 33 seconds popping up. And 7 minutes and 26 seconds popping up. So it appears they're a little bit different, but fairly close.
Perfect. Thank you, Your Honor. May I begin now?
You may. Go ahead when you're ready.
Good afternoon, Ms. Perkins. I'd like to start by talking about your relationship with Avery Becker.
Of course.
You and Avery Becker were best friends.
Yes, we were.
You did everything together,
Yes, we did.
including mock trial.
Yes.
And Avery was good at mock trial.
Yes, she was the best, but I wasn't very good. But I just followed her because she was my best friend.
But she often butted heads with Coach Brackman.
Yes, as I stated, they kind of had a little funny little feud going on, which I never wanted to get in the middle of.
So that's a yes?
Yes.
You don't think Coach Brackman liked Avery?
Objection, Your Honor, speculation.
Any response?
Your Honor, this is not speculation. I asked the witness of their opinion, which is rationally based.
Any reply?
Yes, he is clearly trying to get the witness to explain what she believes about something that is going on inside of Mr. Brackman's mind, which she does not have an availability to answer.
All right. I am going to allow it over objection. You may answer if you're able.
You don't think Coach Brackman liked Avery?
As I don't think I can testify to what goes on inside his mind, but from what I observed, they both kind of butted heads a little bit.
He was always giving her a hard time about something?
Yes, as I stated, she came late and unprepared, and I mean, any teacher or coach would be kind of frustrated if a student did that.
So that's a yes then?
Yes.
This eventually led to Coach Brackman demoting Avery down to the B team.
Yes, that is correct.
And you, being the good friend that you are, quit the team so that Coach Brackman had no choice but to put Avery back on the A team.
Yes, I felt that the A team would be better with Avery on it than with me.
But things didn't get better between Avery Becker and Coach Brackman.
I don't believe they did.
In fact, they got worse.
I believe so, yes.
Let's talk about the day that Avery Becker vandalized Coach Brackman's car. During practice, Coach Brackman was pretty mean to Avery.
Yes, he was shouting at her a lot.
Telling her that she didn't deserve the mock trial awards that she'd won at the tournament.
Yes.
And this upset Avery.
Yes, I mean, how would you feel if you were getting yelled at and told that you weren't good enough?
So that's a yes, then it upset Avery.
Yes.
So Avery wrote on Coach Brackman's car with a marker.
Yes, I remember her going from the whiteboard where she was using an expo marker to, and then vandalizing his car, yes.
And Coach Brackman found out about this?
Yes, he did.
And kicked Avery off the team?
Yes, he did.
And Avery liked to play some pranks on the coach, correct?
Other than the vandalization, I don't recall any, at this time, I do not recall any other time that she would prank him.
Right, but this prank this day backfired.
Yes, it did.
However, Avery was desperate to get back on the team.
Yes, I mean, it was her life. Like, it was her life. She was trying to get back on the team.
And you knew that Avery could be rash.
Yes, along with being late and unprepared, she was very spontaneous, but I wouldn't use the word rash.
Let's talk about the days leading up to the murder. The day before Coach Brackman was murdered, you were with Avery Becker?
Yes, the day before the murder, we went to the mall and then ended up at the Fry Shack.
And at the Fry Shack, you ran into some mock trial people?
Yes.
Objection, Your Honor. The witness has already answered this question multiple times.
Any response?
Your Honor, I'll move on.
Okay, you may.
Avery got upset and stormed off.
Yes.
The next day, March 6th, Avery picked you up from your house that morning?
Yes, that is correct.
And it is your position that you spent the day searching for Avery Becker's phone?
Yes, it is. We just retraced our steps through the mall and then ended up at the Fry Shack later that day.
And even though you know because Avery had an iPhone, you could have just used the Find My iPhone app to locate it?
Your Honor, the witness has already testified to these questions again.
Any response?
Your Honor, the witness has not testified to this question on cross-examination. That has been answered on direct examination. However, I'm still allowed to ask it.
Okay, I'm going to allow the question over objection. You may answer.
And even though you knew that because Avery had an iPhone, you could have just used the Find My iPhone app to locate it?
Yes, however, I realized that I had an Android and you can't do that you can't find an iPhone with an Android. I realized a couple days later, that we could have just used that cloud to find it, but I hadn't had that idea.
So you drove around town trying to find it?
Yes, that's correct. We retraced our steps.
And you maintain that you were nowhere near Coach Brackman's house that morning?
I do not recall the exact route. The only thing that I can remember from that day was us retracing our steps at the mall and going through each store and then ending up at the Fry Shack.
So you were nowhere near Coach Brackman's house that morning?
Not to my knowledge, no.
Because you know where Coach Brackman lives?
Yes, I know the general vicinity.
No further questions, Your Honor.
All right, thank you. Any redirect?
Not at this time, Your Honor.
All right, thank you. Then Ms. Perkins may step down from the virtual witness stand. And with that, for the defense, how would you like to proceed with your case?
Your Honor, the defense calls Avery Becker to the stand.
Okay. And for witness Becker, again, I will remind you, as I've reminded the other witnesses, you are still under the oath given at the beginning of this proceeding. Counsel, you may go ahead when you're ready.
Thank you, Your Honor. Good afternoon, Ms. Becker. Can you please state your full name for the court?
Yeah, my name is Avery Becker.
Can you please tell me a little bit about yourself when you were in high school?
Sure. So I graduated last year, and while I was a student at Colorado High School, I was also a member of the mock trial team.
How did you become involved in the mock trial team?
Freshman year, me and my friend Taylor Perkins wanted a fun way to get out of the house, so we decided to join mock trial together.
Can you explain what happened Tuesday night after your regional mock trial tournament?
Yeah, so we were working at the whiteboard working on our case, and me and Coach Brackman got into a disagreement about my performance, and I left practice.
Then what happened?
Well, as I had left practice, I still had the whiteboard from the dry erase marker from the whiteboard in my hand, and I had written on Coach Brackman's car, which I feel awful about.
What did you do when you thought it was a dry erase marker?
Like I just said, I wrote on his car, and I feel awful.
What happened the next day?
I wanted to apologize to Coach Brackman, so I went to his office, and he didn't want to see me, but I really wanted to apologize in person. So I ended up texting him and apologizing. I said that I would get a job this summer to help pay for the repairs, and I would even scrub the car clean myself. I felt so bad about it.
Where were you on March 5th, 2020, the day before Brackman's murder?
I was hanging out with Taylor, and we were at the Fry Shack, and then we later went to the mall.
Was there anyone at the Fry Shack you recognized?
Yeah, we saw a lot of other Colorado high school students.
What did you do first thing on what? Let me rephrase. What did you do first thing in the morning on March 6th, 2020, the day of the murder?
Yeah, so I went to go pick up Taylor before school, and we realized that I didn't have my phone. So we decided to go back to the Fry Shack and back to the mall and try to find my phone, you know, retracing our steps, calling it at like the stores we were at and the table we were at the Fry Shack.
Did you ever try calling your phone?
Yeah, we called it every place that we were, and just so we could like hear it and see where it was.
What was your relationship with Alex Cifuentes?
Me and Alex were never really friends. We were just kind of like members on the same mock trial team.
Would you normally text Cifuentes?
No.
Did you send any text to Cifuentes regarding being reinstated on the mock trial team?
No, I did not.
Who was Alex Cifuentes friends with?
At mock trial, Alex tended to hang out with Blair Rollins a lot.
Do you remember anything about Blair Rollins?
Yeah, I remember last year people talking about how Brackman was her dad's defense attorney and how he ended up losing the case. And I think her dad ended up going to jail for life.
Do you know where Blair Rollins is now?
No, after graduation, she kind of just disappeared, and I don't think anyone's heard from her since.
Thank you, Your Honor. No further questions.
All right, thank you. I will turn it over for cross-examination.
Your Honor, and before I begin, can I just also get a time check?
Okay, if both of the timers could put it in the chat, how much time is remaining? Got 3:15 and 3:08. So again, close, a little bit different, probably with all this starting and stopping for objections, but they're fairly close. You've got a little over 3 minutes.
Perfect, thank you so much. All right, good afternoon, Ms. Becker.
Good afternoon.
Let's start by talking about the difficult relationship you had with Coach Brackman. You two didn't get along very well.
No, we had our disagreements.
Right, you would argue at almost every practice.
Argue's kind of a strong word. We would just kind of disagree on things.
Is it your testimony today that you didn't argue with Coach Brackman at every practice?
I just think argue is a strong word, but we definitely would disagree on things.
You felt that Coach Brackman would unfairly accuse you.
Sorry, what was that?
Let me rephrase. You felt that Coach Brackman would unfairly accuse you,
Yeah, that's how I felt.
and that he always criticized you.
Yeah, I felt that he was harder than me and most other team members.
And a month before the regional mock trial tournament, Coach Brackman demoted you down to the B team,
Yeah,
which was a team you felt was full of losers. Was that the word that you used?
losers was a strong word. I'd been on A team for a while.
Again, Ms. Becker, I'm using your words here.
Yes.
So this was upsetting to you.
Yeah, it was.
You tried everything to convince Coach Brackman to put you back on the A team.
Yeah, that's correct.
But this wasn't even the worst of your relationship,
No.
because after the regional tournament is when your relationship reached a boiling point.
Yeah, we had a really big disagreement.
Right, let's talk about what happened. You performed very well at the regional tournament.
Yeah, I won the Best Attorney Award.
Right, but you did it by going against Coach Brackman's advice.
Yeah, I went against his advice, but it's what I felt like was right in the moment.
And this didn't sit well with Coach Brackman.
No.
And that made you really angry.
Yeah, I was upset. I just felt like I had done really well, and I just wanted my coach to be proud of me.
You called him the worst coach in the state.
Yeah, I was really upset.
You stormed out of practice.
I did.
Saw Coach Brackman's Porsche and wrote in giant letters across the hood, Worst Attorney Award.
I know, and I feel awful about that. I wish I hadn't done it.
And that's when he kicked you off the team.
Yeah, that's correct.
And that made you mad.
Yeah, I was really upset. I loved mock trial, and I was really passionate about it.
You went home to your mom and told her that you were kicked off the team for no good reason.
Yeah, I was really upset.
But you didn't tell her what you had done to his car.
Yeah, I was really ashamed, and I just wanted to tell her about how I'd gotten kicked off the team.
Not only did you fail to tell her the truth, but you swore to your mother that you'd get back at Coach Brackman if it was the last thing you did.
Yeah, I wanted to show him that I was a good attorney and that I deserved to be on the team.
So that's a yes, you told that you would get back at Coach Brackman if it was the last thing you did?
Yeah, I wanted to get back at him and show him that I was a good member of the team.
Thank you. No further questions, Your Honor.
All right, thank you. Any redirect, Ms. Pensoneau?
Yes, Your Honor. May I request a time check before I begin?
You may. And again, from the timers, if you could put it in the chat feature, please. Got 3:38 and 3:40.
Got it. Thank you. Ms. Becker, after that statement you made about threatening Brackman, how did you feel after making that statement?
I felt awful. I was just so upset, and I just, really cared about mock trials. So after being kicked off the team, I was upset.
Thank you, Your Honor. No further questions.
All right. And any follow-up based on that limited redirect?
No, Your Honor. Thank you.
All right. Thank you. And with that, how would the defense like to proceed?
Your Honor, we have no more witnesses to call to the stand. So if we may, we could begin with our closing argument.
Okay. And so the defense is resting at this time then?
Yes, Your Honor.
All right. Thank you. Well, then I will note that the testimony and evidence is closed. I will allow both sides to make their closing statements. I will begin with the prosecution. So the prosecution, if you'd like to make a closing statement, you may go ahead.
I would get back at him if it was the last thing I did. And on March 6, 2020, Avery Becker fulfilled her promise. She finally got back at Mackenzie Brackman. Here was her plan. March 6th, she skipped school, went down to Coach Brackman's house at 444 South Flower Street, where she knew that he lived, and broke into his house. She just wanted to break in, cause some trouble, vandalize his house, just like how she vandalized his car. She didn't expect him to be home, and she was surprised to be greeted by him because he had been alerted to an intruder breaking into his home. Mr. Brackman met her with a knife at the back sliding glass door, and they grappled over that knife. Avery Becker won control of that knife and stabbed Brackman in the back, ultimately leading to his death. I would get back at him if it was the last thing I did. We brought forth 2 charges in today's case against Avery Becker. And in just a few minutes, I'm going to ask you to go back and deliberate on those charges. So it's very important that we understand what those are. The first one, burglary in the 2nd degree. Avery Becker went to Coach Brackman's house with the intent of breaking in and causing criminal mischief. And she did just that. Now, this next charge is a bit more complicated. Murder in the 1st degree. What this means is that during the course of her breaking into Mackenzie Brackman's house, there was a death. And that death was Mackenzie Brackman's. It is very important to note that in order for you to find her guilty of murder in the 1st degree, it does not matter if she intended to kill Mr. Brackman, just that it happened. So let's go through the facts in this case. You heard from Detective Markowitz that Avery Becker was at the scene of the crime at the time of the murder. We know this based on her cell phone records and also from the text messages that she sent Alex Cifuentes laying out her plan to break into Mackenzie Brackman's house. We know that Avery Becker was there. We know that she was the only one with a true motive to commit this crime, and she alerted someone to her plans of this crime. And then miraculously, those plans got done. You heard from Taylor Perkins, who corroborates Miss Becker's alibi. But you also heard from Taylor Perkins that she idolizes Miss Becker. She is devoted to Miss Becker. She would give up her spot on the mock trial team for Miss Becker. So put Taylor Perkins' testimony aside because she would do anything for Miss Becker. Instead, listen to Avery Becker herself. Listen to what she told her mom. I would get back at him if it was the last thing I did. Avery Becker had the motive, the means, and the opportunity to commit this crime, and she is the only person in this courtroom, in this world, that could have committed this crime. The evidence points to her, the build and body shape on the ring cameras points to her, the CDR records that place her cell phone there point to her. The defense wants you to believe that somehow Avery Becker had the unluckiest day of her life. Someone stole her phone and then took her phone to go commit a crime and plant text messages on her phone. That is unreasonable. They have no evidence to substantiate any of these theories. We have evidence to prove Avery Becker was at the scene of the crime, 444 South Flower Street. She had the motive to do this, she had the means, and she had the opportunity. She wanted retribution against Mr. Brackman, and that's what she got on March 6th. Thank you.
All right, thank you, Ms. Brockler. Ms. Pensinel, closing on behalf of defense.
Yes, Your Honor. Members of the jury, carelessly performing a job will never give you the proper results. And in this case, the poor results are also a grave injustice. Mackenzie Brackman was an attorney who fought for justice, yet neither he nor Avery Becker will receive justice in this case if the police's many failures are left uncorrected. Today, you heard and saw evidence proving the countless mistakes the investigating officers made. First, they made up their minds before the evidence even began, taking the easy way out and ignoring important evidence. Second, the police failed to consider relationships and motives that exonerate Avery Becker. And third, the police's investigation was replete with unreliable shortcuts and omissions. The murder of Mackenzie Brackman demands justice, but from the very beginning of the police's investigation, justice has been compromised. First, the officers took the easy way out and ignored important evidence. They had their minds made up before any evidence was collected. They should have looked at the cell tower records of Taylor Perkins' phone to confirm Avery Becker's alibi, but they weren't concerned with evidence that disproved their initial theory. Detectives earnestly seeking the truth would have examined the numbers and data of all the phones in the area at the time of the murder and determined if any of them had a connection to the victim. However, the investigators in this case failed to complete this obvious step. Second, the police failed to consider the relationships and motives that exonerate Avery Becker. They did not investigate the relationship between Miss Becker and fellow student Alex Cifuentes. Taylor Perkins, a friend of Avery Becker, not someone she idolizes, explained that Cifuentes was jealous of my client and was always competing with her for the top spot on their mock trial team. The police didn't take this relationship into consideration, and as a result, they accepted unreliable testimony from Cifuentes that heavily influenced their investigation without considering her bias against Becker. You also heard how the DPD overlooked other suspects. Where is Blair Rowlands, an obvious potential suspect with more motive than anyone else? The police didn't even bother to take the first steps to gather information on that lead. Third, the investigation was replete with unreliable shortcuts and omissions. Professor Blake Van Owen, an expert in police investigation tactics, testified that this investigation was rushed, negligent, and incomplete. Van Owen explained that the police had a forensic technology called Celebrite, a program that easily allows police to download the contents of any cell phone. The investigators' failure to use this software is an inexcusable shortcut that further proves that their minds were made up before any evidence was even collected. Furthermore, Van Owen dispels the belief that CDR is completely reliable. Even the prosecution's own expert witness, Detective Markowitz, confirms this. Markowitz also acknowledged her own omissions. She never interviewed any of Brackman's ex-clients or requested cell tower records from them. And she relied on screenshots of purported texts which can be easily manipulated and tampered with. What about the photos of the blood splatter? Corrupted, a result of mishandling evidence. And finally, you heard from Avery Becker herself. She was with Taylor Perkins on March 6, 2020, not at Mr. Brackman's house. The reliable evidence supports this, but the police knowingly failed to consider or gather it. Moreover, you heard Ms. Becker testify when she inadvertently vandalized Mr. Brackman's car. She felt horrible. She was ridden with guilt, and she tried to do everything she could to repair her mistake. Trying to apologize in person, texting, and even offering to work a job all summer long to pay for the repairs. Avery Becker could not stomach the idea of marking up a car with a Sharpie. This is clearly not a girl capable of murder. This crime has already claimed its first victim. Do not let it claim its second. Members of the jury, the prosecution must prove beyond a reasonable doubt that Avery Becker committed two crimes she is charged with: murder in the first degree and second-degree burglary of a dwelling. The prosecution has failed to prove several essential elements of these crimes. Noticeably, there is significant reasonable doubt that Avery Becker was even present at Mr. Brackman's home. There were potential theories and promising leads from the very beginning that the investigators completely failed to pursue. The prosecution has tried to tell you that Avery's biggest motive I apologize. The prosecution has tried to tell you that Avery Becker had the biggest motive yet, but that isn't true. Mr. Brackman deserves justice, and Avery Becker does too. The evidence points strongly toward there being another suspect with stronger motives. We ask that you return a verdict of not guilty.
All right, thank you. And I did let the prosecution reserve any time remaining for rebuttal. Do you need a time check, Ms. Brockler?
Yeah, can I ask how much I have left?
You may, and the first timekeeper is saying 121, second timekeeper, oh, they're both saying 120 and 121. So you've got at least a minute 20.
At least someone's reaching a consensus in the courtroom.
All right, you may go when you're ready.
Avery Becker is guilty of burglary in the second degree and of murder in the first. Let's talk about this investigation that the defense claims is rushed. This investigation started with a launching point, finding that Avery Becker had a motive, those text messages. Even if you don't believe those text messages, we heard from Miss Becker herself on this stand that she told her mother that she would get back at Mr. Brackman if it was the last thing she did. And it's no surprise that on March 6th, she finally did that. She did what she said she was going to do. And look, the defense wants to say that these CDRs are unreliable, even though their own witness, their expert witness, wants these CDRs to corroborate Miss Becker's story. These CDRs place Avery Becker at the scene of the crime. Her build and body shape place her at the crime. She had the means, the motive, and the opportunity to commit this crime. It doesn't matter if she intended to cause the murder, it happened. That's murder in the first degree. She broke into that house with the intent of vandalizing it, just like she did the car. That's burglary in the second degree. Let's give Mackenzie Brackman the justice that he deserves. Find Avery Becker guilty.
All right, thank you. Well, that concludes this round of mock trial. So thank you, everyone. I'm going to give my scoring panelists some times to get all of their scores submitted, and then we'll do some feedback, some comments. But I don't want to start with comments until all the scores are turned in. So, and if everyone wants to turn their cameras back on for the comment portion, that would be great.
And for my scorekeepers, if you want to turn your cameras on and just give me a thumbs up when you're done with scoring. All right, Ms. Valenta, you're finished. Ms. Burnett, you're finished. And what am I missing here? There we go, Ms. Ferraza, I saw your thumbs up as well. Okay, gotcha. Thank you. Okay, well, first of all, I just want to say this was an awesome job by both teams. I think you did really well this round. I would expect your scores to be pretty high based upon your performance. I also judged around last week, and you guys were right up there with the teams I saw from Arapahoe County last week. Congratulations to both teams. I thought you did some really excellent things. I actually had the pleasure of serving on a real jury this week. And I have to tell you, you guys were just as good as the professional attorneys. It was just careless driving. So that was the only charge in the trial I served as a juror on. Surprised they didn't kick me off, but they kept me on the jury. And you guys were right up there with the DA's office and the private defense attorney as far as case presentation. So I just want to say, awesome job. I really liked for the prosecution how you tied your theme together. Specifically, the opening statement, Mr. Aragon, you indicated, you started with that the defendant had said, I'll get back at him if it's the last thing I do. That was repeated and emphasized. That was the last question that Mr. Aragon also asked when the defendant was testifying. And then right into the closing statement, Ms. Brockler, you used that same statement. So you kind of tied your theme together really well, which I thought was really good. The opening statement for the defense, Ms. Proctor, you did an awesome job. You had so much information though, so you need to cut some of it, right? And slow down a little bit to make a point. But you had a really good way of presenting your opening statement, saying you will hear this, you will hear that, and emphasizing that. So that was really good. But I think unfortunately you just have too much in there. So I'd recommend when you move on to the next round, cut some of it out and slow down a little bit. I don't know, there were so many, I have so many comments, but we don't have a lot of time. I know you have to get to the next round, but I just have to say overall, everyone did awesome. I thought there was a great debate on whether Professor Van Owen was qualified, the voir dire and the back and forth between Ms. Dragovich and Ms. Brockler. That was also a standout point. You guys both did a good job making good arguments. Professor Van Owen, I think it's Ms. Greenfield, you were pretty convincing. And almost a little difficult, but not on purpose, but trying to be, but not, kind of that balance. I thought that was, a good job as well. Again, I have many points, but I'm going to let the other scoring panelists have a few minutes here to give comments as well. Who wants to go first? Ms. Ferraza? We can't hear you right now.
Hello?
Gotcha. Go ahead.
Sorry. I wanted to hop in real fast. Unfortunately, I have a hard stop at about a minute because I had a situation come up with a case. However, you all did absolutely great. I'm really honestly blown away. The judge is right. The scoring, at least on my end, was really impressive. The only thing that I would say is I thought the professionalism was good. I thought that the objections were really good as well. I would say one piece of constructive feedback, Mr. Aragon, you do have a tendency to ask leading questions. I do as well, which is why I specifically noted it. And for example, it's just things for when you're asking direct questions, saying, what else did you find in the kitchen? Instead of, did you find something else in the kitchen? Or why was that significant? Instead of, was it significant? Just minor things like that. Like I said, the only reason why it stood out to me is because it's something that I do all the time on direct examination and something that I've had to work on a lot because it's so easy to do. Otherwise, I would say when it comes to the defense, try to go a little bit easier on the police department. They're not there trying to, commit somebody of first-degree murder intentionally. I think that it was good that you emphasized that, they weren't thorough in their investigation. They were maybe kind of not as thorough or kind of took the easy way out. I think that was a good emphasis, but I think going so far as to say, that, maybe they intentionally didn't complete a thorough investigation or something like that is a little bit of a stretch. I would also say in the prosecution's opening, they said something to the effect of, "We welcome the burden of proof." I don't know if I would go that far because this is a murder trial, but I did like the confidence by both parties, honestly, and I thought you all did a fantastic job. I think those are the only specific notes that I have, but you guys really rocked it. So I think you have a lot to go home and be proud about and go to the fry shack or whatever that is and get some fries and milkshakes. So I was honored to be here. Thank you for letting me be one of your scoring panelists. Feel free to reach out to me if you have any further questions or follow-up. I apologize I have to hop off, but good luck.
Thank you, Ms. Ferraza. All right, Ms. Burnett, do you want to go first? I mean, next?
Yeah, wow, guys. I did this last year, I judged last year, and I'm just as impressed as I was the year prior. Just like Your Honor said, your guys' scores were extremely high with me. Just wow. So I'm going to keep this short and sweet because we are running out of time. Witnesses, try to calm your emotions when opposing counsel is unraveling you. That's their job. Their job is to get you frustrated, but if you focus more on your frustration, it loses your testimony. I have to give this shout out. Amanda, you did an amazing job. You came with the information and your facts, and you hit your case, and you came to play, girlfriend. So awesome job. And guys, just amazing job. That's all I have to say. I'm just so impressed with this round. Amazing, amazing. That's all I have.
Thank you. Ms. Valentich, did you want to give some comments?
Sure. I mean, I agree with most of what everyone has said. I think you guys did an amazing job. It's hard to believe you're in high school. And I think you all were super professional. You had good demeanors. I agree with Sarah that sometimes the witnesses got a little heated and you want to, make sure that the jury likes you. I don't practice in front of a jury. I just practice in front of the judge because I do family law. So being kind of a, lay person here today, sometimes I was like, oh geez, like that's a little too much. And then let me look at my notes. Yeah, Ms. Proctor, I think you are a great storyteller. I think you just have to cut down a little bit on your opening, and so you're not rushing so much so that we can listen to you better, because you are really interesting to listen to. You do come across really well. Mr. Aragon, you speak very clearly. Your opening was engaging. Everyone did a good job with responding to objections, and then repeating your question and getting back into your examination to make sure you and your witness were on the same page there. So I thought you all did a good job at that. I thought you were all super professional, and I think you all did a really great job. So congrats.
Yeah, I agree. And with the objections too, I mean, it's real life, when you're in court as well. Sometimes you're going to agree with what the judge has decided, and sometimes you're going to sit there and think, oh, that's wrong. But you can't let the judge see that, right? You just got to say, okay, thank you, and you move on.
Yeah.
Even if the judge is wrong, judges are wrong all the time. So,
yeah, I will say a couple of you got a little bit defeated after your objection was. Oh, sorry, I thought I had a call coming in. A couple of you got a little bit defeated, so I would say just keep on going. Don't worry about it. And then sometimes when you guys mess up, you're like, oh gosh, I'm so sorry. Oh my gosh. We don't notice. 1 second to you seems like 30 seconds, but it's really 1 second to us. So a lot of the time you guys would be like, oh, I'm so sorry. And I was like, I didn't even know you messed up. It hadn't clicked for me yet, but I know that happens to me too. I think you guys did a good job with the technology. I had a case the other day where my witness couldn't open her exhibits, and I had to make sure my desktop was clear of confidential information and try to screen share and pull things up. And so it happens every single day. It happens in real life. So don't worry about it. You guys, rolled with the punches, and that's all you can do.
Yeah. And if you are flustered, all you have, you can always say, Your Honor, can I just have a moment quick to check my notes? And then you can just like look at nothing and take a deep breath if you need to. That happens all the time in real life. In real court, attorneys always say, can I have another minute to check my notes? And then they may have one last question or not, but that's normal. And I just wanted to say again, good job to everyone. It's interesting, when the prosecution said we welcome that burden in this case, that's the same thing the prosecution said when I served on a real jury this week. So that's fine. But when you're the defense, then you hear that, right? You got to listen to the other team, not just take your prepared, pre-planned notes, add to it. And when you get, to your closing statement, the defense could have taken that and said, they welcomed the burden and they didn't meet it. They didn't give it to us. They didn't, show us or, meet their burden. So if you hear something from the other team too, it's always okay during the course of the trial to change your notes, make sure you're actively listening and then using that to your advantage if you can. So again, I think your scores are going to be very high on both sides, both teams. I really do. So good luck and good luck in the next round that I think starts here pretty soon. So thank you all. Take care. And if you ever want to reach out or have any questions, you can always contact me or the other scoring panelists, if you have anything further. All right. And for the courtroom monitor, I believe we're free to go.
Yes, thank you.
Okay. And then you'll hear about your reassignments for the next round shortly. All right. Thank you, everyone.